68.
Page number 2, item 6 and 7. Page number 3, item 8 to 17.
My lord, item number 8, my lord. My lord, there is some defects which have been pointed by the SR. Maybe a week time may be granted just to remove those defects, my lord.
Your Lordship,
Yes.
Your Lordship, item number 15 has become infructuous, Your Lordship. Item number 15.
Why?
Where the person has been rescued, Your Lordship.
Page 4, item 18 to 24. Page 5, item 25 to 31. Page 6, item 32 to 35. Page number 7, item 36. Page 9, item 37 to 39.
37, please. My lord, Mr. Tripathi is out of station, my lord. Please, next week, my lord. As per instruction, my lord, basically, the council has been instructed.
I am for the opposite party. Lordship, I will keep to next Monday.
Next point is not possible.
A day after tomorrow, Lordship, is a considered matter.
But both of you are for the same side. You and Mr. Tripathi are for the same side.
No.
You're not for the opposite parties.
Yes, I am for the.
He's also for the opposite party.
I'm for the appellant, my lord. Mr. Tripathi is for the appellant, my lord.
The name is appearing. Then there are two BP Tripathis. Name appears for the respondent.
It's paid on 18 September. Should be more particular council instruction of the particular council in the split on 18 September. Mr. You're Mr. Dunn.
Yes, Mr. Chattu.
Mr. Chattu, yes.
Is for
Page 10, item 40 to 43. Page number 11, item 44 to 48. Page 12, item 49 to 52.
49, my lord. I am for the respondent. I am today filing the counter with the objection that maybe I will solve the copy in the state.
counter in the state of what?
Counter in the state. I am for the respondent. We declare to be illegal, my lord. Counter in the state of the constitution. I will have
What is the good thing, sir?
Mr. Sandhu. It's already up here. I am to be filing the request. May it please, your lordship.
Why is the respondent party my number 48 of 2022?
Next. In that case, we will not continue.
And one is the response, which was coordinated by the subscription and yes.
Item 41 will also assume the interim order to continue. There is an interim order.
Fortunately, was not passed any order, just how all this interim order contribute in the next page.
Page 13.
Item 15.
Item 53, sorry, item 13, page 13, item 53 to 55.
You are on 55?
58, my lord.
Page 14, item 56 to 62. 58 is there.
58, my lord. I am the opposite party. My lord, senior Mr. Maheshwar Mahanti is ill and they are correct to watch next week.
Item 56, my lord.
Take it.
For the appellant.
You are for the appellant.
Yeah, for the appellant.
Yes, my lord.
Item 56, my lord.
It's 15.
Yes.
Item 56, my lord, may be taken up today at 2. The matter is urgent and I have a case in the Karnataka High Court today in the first half. May it be taken up at 2 after lunch. Obliged.
Page number 15, item 63 to 69.
My lord, item 68, there is a personal appearance of the opposite party along with the children. May I pray your lordship may kindly take it up at 2 because he has come from Pune with the children.
Item 68, I am appealing the petitioner, my lordship, on behalf of the white, my lordship. I also.
At 2 p.m.
What is the date?
Date is today.
Time not today.
You are here 21/7/2023. That is notice has been issued to personal appearance of the parties.
That's what she's saying.
My lordship, 21/7/2023. But the my lordship, I only
At 2 p.m. At 2 p.m.
The court.
That it is up to your lordship. Your lordship.
the matter will not reach. For that reason, I will pray before my lordship before the bench will rise, my lordship.
All right, let them come, let them mention the matter will take up. If it's right, it's
Okay.
chamber that will take the matter to chamber.
Obliged.
No, I see very different.
He has already been appeared, my lordship. Isn't my lordship? For that reason,
No. They are not here. So madam is mentioning that 2 p.m.
2 p.m.
Once they reach, you mention. That's for the time.
Yes, I am there. I will mention.
They have reached.
They have reached. I have told them to come at 2 because
All that, comment. That's it.
Page number 16, item 70 to 72. Mention moment.
So one criminal appeal where a bail application was dealt with by my Lord Justice S.K. Mr. Deven was and my Lord Justice RATHO. So now again I'm finding a miscase for bail. It has to be before this bench.
Further, madam.
Yes, ma'am. Any date subject to lordship convenience. I don't have to mention. So EIL matter. So EIL matter means the damage was encroached. Now it was in the 25th wide. Now it was found.
This is a PIL matter but the eviction of the villagers. There is 60 years residing there. So urgent to kindly praying for.
For 50 years they are residing there.
60 years they are residing there, but now they are evicted forcefully.
So there is a, why did how this court is interfering?
It will be single bench.
Where is the PIL matter?
How it can be a PIA?
So you are for the encroachers or for the petitioner?
For the petitioners.
No.
Encroaches. Now that can be a PIA, I don't understand. It's
If
individual.
the encroachers are petitioners, they have to move before another bench. That is
exactly that
the,
is-
under the.
No, probably in a PIL they have been directed to be evicted. Fine.
This is not a PIA, we will not entertain. If you are going to vote, this will not entertain. You think later on come to us. This cannot be PIA.
Eviction matters are for some single bench. You check up.
And moreover, single bench, if these are under the unauthorized documents act, there is a remedy there, you can move to that remedy. We are coming in the PIL. Or they just check up the matter. It cannot be PIL.
Yes, ma'am.
My Lord, on the petition online mention it was listed on 3rd August, but could not be taken up. May I pray let it be taken up list. Pardon mention, my Lord. Date of bill precedence. Rate of petition challenge is order of the 28/7/2000 passed by the honorable single judge.
That's all right. When you file the writ appeal. When have you filed the writ appeal? And on which date you have filed the writ appeal?
Order passed 28/7/2023.
That is by the single judge.
Yes,
I'm
ma'am.
asking you when you file the appeal. Or it will come automatically otherwise. Wait for someone that is not listed, then make the mention.
The rate appeal matter, the 13/14 of 2023 is a apprehending or termination matter against the order of the honorable single judge. So that's it. My lord, this is the petition for restoration matter.
When the order of dismissal was passed,
The 8th February matter.
8th February, which year?
2023.
2023. Order.
Pardon, Lordship, kindly mention CRLA number 410 of 2023 is a special act bail matter. Lordship, in this appellant was custody more than 5 years, Lordship. And in the meantime, all the appellants are on bail.
But the designated,
Lordship, for permission of the Honorable Court,
go to the designated, there is a designated bench for this.
it's a last because of Honorable Justice S.K. Saha has been transferred to with the permission of the Honorable Court. Last 2 years, this matter has been not.
Mention before this court. There is a difficulty to look into that. Mention before the court, especially cannot undertake this. Clear in the invisibility system.
It's earlier rejected by some bench.
Lordship,
Which bench?
Lordship, Honorable Justice S. Pujari, Lordship.
Oh, then it will come up before the regular bench.
Or just check out.
We are going to ask you.
This is a fresh admission matter. It was listed first before Honorable Justice B. Ratho. But being a division bench, it has to come before your Lordship. Supplementary list, fresh admission item number 1.
May it be your lords. In this case, last 2 occasions, the Honorable Court directed to file counter affidavit. My learned senior till yet not filed the counter affidavit, my lord. My matter relating to illegal selection of plot for construction of Orissa Adarsh Vidya building. Dakshinawada Kasmula. Instead of village Dakshinawada, the opposite parties have illegally selected a plot at village Rampo, my lord.
How it is illegal?
My lord, government of Orissa is for construction of Orissa Adarsh Vidya have selected the place Dakshinawada, my lord. But the site selection committee being influenced have selected a plot at village Rampo, my lord. Which both are coming under similar block, but other panchayats, my lord. My lord, we have not filed the counter affidavit, but I may be permitted to draw your lordship's attention to 3 documents which are annexed to the writ petition. Your lordship may kindly have a glance on annexure 2 at page 17. I am placing WPC 36413 of 2022. There are 2 matters, 36413. There is a site selection committee, and kindly see who are the signatories to this site selection, who are the members of the site selection committee, they have put their signatures below the decision. Just a minute, just please wait. And this site was selected in as early as 2018, 5/10/2018, 5 years back. And your lordship will find in the prayer, there is no prayer to quash or set aside this decision of the site selection committee. Now, basing on this site selection committee, next document your lordship may kindly see at page 18. There is a administrative approval of this much of amount, 7 crore something, for construction of the building. This is of the year 2021, 2 years back. And then your lordship may see the representation of the so-called petitioners or some villagers. That is of the year 2021. Now, the PIL is filed on 4th January 2023, after 2 years. 2022.
What is the status of everyone here?
That is what I beg to submit. That in the meanwhile, that the construction, either it has been completed or that has to be, instruction has to be signed.
On last occasion, my lord senior mentioned that the building is almost completed at village Dakhinawada. But my submission is that, my lord, they have selected a plot at village Rampur, my lord. Kindly see page 18, my lord. Page 18. Approval, my lord. Officer, my lord.
Yes.
Administrative approval is hereby accorded to the works construction of OAV core building at Dakhinawada at Rampur. Dakhinawada is separate place and Rampur is a separate place.
May I be permitted to place the status of the within 15 days? I will give us with photographs. What is the actual stage of your lordship may direct on that?
I will first order, my lord.
State. Diplomatic instead of the first of all, this and respect the religion and also the strategy conspiracy
At the present location.
Construction in terms of the office order dated 19/4/2021 and secretary to the certification. You, Mr. Senapati.
My lord.
Mr. Shatruguru Senapati, 2000 petition. Let us see that it was what they said.
Item number 2. Oblige.
May please, your lordship. May.
Item 2, may please. Heard an appeal before the first appellate authority, that was also rejected. I have challenged it before the
State Commission.
National Commission. It is a central government.
Central government.
That was also rejected. Against which I had preferred a writ petition. That was also rejected without assigning any reason. On particularly when the respondent.
Union of India. Anyone?
Yes, my lord. Yes, I am appearing, my lord, in virtual mobile.
All right, we are admitting this appeal. It will be returnable on 18th of September, I think.
Yes, my lord. But my lord, this they have implemented the cabinet secretary's party. OP number, respondent number 2. So we are not a necessary party for which you find an application for diligence.
But all right.
No, sorry, your lordship. It is his notification. Cabinet secretary notification. He is the necessary party. It is his notification.
What kind of notification that?
Your lordship, kindly go to page 57. Before the second appellate authority, page 57, they have stated the appellant for this application dated so and so copy enclosed under the RT Act had requested to furnish a copy of the cabinet secretary notification so and so related to RRs. RR means recruitment rule. Recruitment rule for the post of a miscellaneous cadre in cabinet secretariat. Miscellaneous cadre is a class 4 employee. Or then they have formulated a recruitment rule, that copy they are not providing.
Mr. Padi, without issuing notice, I tell you, bring this recruitment
Yes,
rule.
my lord. Lordship may issue notice and we will give the reply.
Please call for this recruitment rule in the seat cover because they are time and again they are saying we are a security organization, we are interviewing organization, we will provide.
I think the copy of the IA may not be served to the Malan Council.
No, because You know, of course, the provision of section 8.
Yes,
The exceptions have been made from the disclosures.
that's right, Your Lordship.
All right, let them come.
24+2 also, the gazette notification we have annexed in the IA.
Whether they file any counter affidavit in the writ proceeding?
Yes, yes.
What the Honorable Single Judge did, that on the past date of hearing, kindly see, I have enforced that cause list also. On the past date of appearance, they did not appear. Still, the Honorable Single Judge refused to dismiss my application without saying anything. And they have filed an IA to bring this opposite party number 2.
You are appealing in person, I think.
Person.
Heard Mr. Sanjeev Kumar Khandatre, the petitioner in person, having examined the impugned order dated 31/2023, which has been challenged by the Central Court of Appeal. We have the view this appeal should be admitted. Admit the appeal to be heard on merit, issue notice. Since Mr. P.K. Pari,
Along with the SS Kashyap.
Deputy Solicitor General of India, along with S.S. Kashyap, appears for the respondents. No, you cannot appear for 3 perhaps, 1 and 2.
1 and 2, yes.
Appears for the respondents number 1 and 2, no formal notice is called for. The petitioner shall take steps for service of notice on the respondent number 3 within 3 working days from today by the registered post with AD. Just I want to know whether this cabinet secretariat is a security organization.
No. It is not a fact, but no, gazette notification has come.
You say that observation has been made somewhere.
No, my lord, we have there is a gazette notification issued by the Ministry of Defence.
But if it is relating to the security organization, of course you have a right to.
The cabinet secretary is covering many things, my lord.
All right, let the matter be clear.
Yes.
Every person doesn't become the security personnel.
Yes, that's true.
Item number 4. May I please, Your Lordship. So here the appellant has challenged the order of the learned single judge, my lord. On last occasion, Lordship directed my learned point to obtain instruction in this matter. But we are filing an affidavit today in the first half. Your Lordship may take this up in the second half. Lordship, let the copy of the affidavit be solved immediately. It can be taken on Friday, my lord.
Friday there will be difficulty, but
My lord.
can it be about the next Monday? 21st, CORAM. Already, so not on Monday, 22nd. Okay, it is come on 23rd.
Yes, my lord.
The matter will be studied on 23rd of August 2023.
So
Mr. A. Behavioral and Counsel appearing for the respondents submitted that the counter will be filed in the course of the day.
In course of the day.
After furnishing a copy to Mr. Swine, K.K. Swine and Counsel for the. We are only K. Swine.
Yes, my lord.
K. Swine and Counsel appearing for the appellant.
Great, my lord. Item number 5. May I please, my lord?
Yes.
Before I take my lord to the impugned order of the learned single judge, my lord, I'd like to place the facts of the case in brief, my lord.
Have you changed this?
Yes, my lord. The correction has been carried out. Well, the facts of the case is in brief is like this, my lord. The appellant and the respondent then entered into an agreement wherein it was agreed that the appellant is going to supply 40,000 of metric ton of iron ore pellets to the respondent, my lord. My lord, as per the appellant, my lord, there was a novation of contract, for which reason the contract could not be worked out. But the case of the respondent is that there was breach on the part of the appellant in supplying the materials, as a consequence of which, my lord, a Section 11 application was filed, seeking appointment of an arbitrator for resolving the dispute, my lord. But the application was filed before the High Court of Madras. The Honorable High Court of Madras allowed the Section 11 application. The matter was taken up to Honorable Apex Court on the point of jurisdiction. Subsequently, the matter was relegated to this Honorable Court, and pursuant to order passed by this Honorable Court under Section 11 application, the arbitrating tribunal was constituted, my lord.
But thereafter, notice is issued. The respondent filed its statement of claim.
Yes.
But we filed our statement of defense. The respondent filed a rejoinder. And all through in the section 11 application, as well as in the claim statement, in the rejoinder, the constant plea of the respondent was the major claim was due to loss sustained by it for purchasing the materials from a party called SR India Steel Limited, my lord. But we find a statement of defense denying our liability. But the respondent adduced its evidence. Its sole witness was examined in chief as well as cross-examined. After, when the matter was posted for our evidence and we had filed our evidence and affidavit, at this stage, my lord, the respondent files an application under Order 23, Rule 3, seeking amendment of the statement of claim. May I just take my lord to the relevant portion? What was the earlier case and then what was the subsequent case, my lord?
What is the decision regarding this amendment prayer of the arbitrator?
That has been allowed, my lord. Okay. I'll come to that, my lord. Your lordship will just kindly for a moment see page 58 of the brief. Page 58 of the brief, para 1.6. My lord, got it?
Yes. Yes.
But in para 1.6, it stated that as a result of non-performance of the respondent, that is the present appellant.
58 of the brief is an index.
My lord?
It is in page for index. The order is also not there.
Annexure 2.
No, but have you just enclosed the annexure 2? That is the impugned order dated 20.
Yes, my lord. That finds place at page 207.
207. Anyway, but this page 58 is the index page.
Annexure 2 says it's certified copy of the order, but when we turn to Annexure 2, it is copy of that petition. Just check, please.
But actually, subsequently, it has been uploaded again, my lord. On last Friday, it was done.
No, Thursday.
So Thursday, it has been carried out.
No, but Annexure 2 is certified copy of the petition, arbitration petition.
But you are supposed to only change the index, not the pages and order.
No, pages, it was all right, but there was only the Annexure 3 was not there on record. So that we had filed it physically, but
we can't find Annexure 2. As per your index, Annexure 2 is the impugned order.
I got it, my lord. Annexure, no, my lord.
As per your index.
As per the index, Annexure 2 is the impugned order. That's right, my lord.
But we can't find it.
Page 207, my lord.
Not 207. Annexure 2 is page starts at page 30.
No, the
Page 30 is the
corrected index is not there, my lordship's record, my lord.
Oh, okay. This is the problem. They will file and it will not be scanned and we'll be wasting time. The file actually no index the
But my leadership is looking at the index of the writ appeal or
writ appeal.
I think the entire dispute on the interpretation of section 23, subsection 3 of the Arbitration Act.
Absolutely correct, my lord. My lord, over here, my lord, I pleaded before the learned arbitrator that allowing this petition would be changing the nature and character of the case. But a defense had accrued in my favor, wherein the case of the claimant was completely demolished. So therefore, a valid defense had accrued in my favor. And subsequently, my lord, allowing this petition would result in a de novo proceeding. But this is not only contrary
the scope in an arbitration case that the disclosure make someone to suffer. That cannot be the principle in the arbitration proceeding.
My lord, over here, not
sure. Just wait. The very principle of arbitration, Unictral also just says that as far as possible, opportunities to be given to give all materials before the arbitrator so that he can take a just decision. This is the basic international principle upon which our act has been also framed.
I quite agree, my lord.
So, and in the decision of the arbitrator, if he says that there is nothing prejudicial to you, you can only claim that let me file also another defense statement. But it's fair enough.
My lord, at what stage, my lord? After he was cross-examined.
Read subsection 3, this doesn't indicate to any stage.
My response
categorical, it says in the proceeding. Means till the proceeding is not closed, the opportunities will be there. It is upon the arbitrator to decide whether he would entertain this amendment or not.
My lord.
All right.
But only thing, my lord. Over here, Order 23, Rule 3 cannot be read in isolation, my lord. I have got judgments, my lord, of the Honorable
All
Apex
right,
Court.
just show us the judgment.
My lord, wherein it has been stated that Order 23 is mandatory in nature, wherein first the claim statement has to be filed within a specific time frame, statement of defense. So Order 23, Rule 3 cannot be read in isolation.
All right, read.
Yes, my lord.
Read Arbitration Act. Section 23.
My lord, Section 23, my lord.
Yes.
My lord, Section 23, Statement of Claim and Defense, my lord. Within a period of time agreed upon by the parties or determined by the arbitral tribunal, the claimant shall state the facts supporting his claim, the points at issue and the relief or remedy sought, and the respondent shall state his defense in respect of these particulars, unless the parties have otherwise agreed as to the required elements of those statements. 2 says, the parties may submit their statements all documents they consider to be relevant or may adduce a reference to the documents or other evidence they will submit. 2A, the respondent in support of his case may also submit a counterclaim and plead set-off, which shall be adjudicated upon by the arbitral tribunal if such counterclaim or set-off falls within the scope of arbitration agreement. 3, unless agreed by the parties, either party may amend or supplement his claim or defense during the course of the arbitral tribunal, arbitral proceedings, unless the arbitral tribunal considers it inappropriate to allow the amendment or supplement, having regard to the delay making it. My lord, over here, my lord, your lordship, and just take my lord to few the judgments which I've relied on, my lord. My lord, so far as the first case is concerned, my lord, that is of Bhavan construction, my lord.
Yes.
In this case, the Honorable Apex Court has said, my lord, knowing the limitations of challenging an order of an arbitral tribunal, my lord, it has said that para 17, in case of an exceptional rarity, my lord, it can be challenged. A judicial review is permissible when a party has shown bad faith and there is one of the parties is left remediless. My lord, so far as the second case is concerned, my lord,
Just a minute. You are referring to para 17.
para 17, my lord.
This is Ramanna's judgment.
Yes, my lord. Para 17, the last paragraph, my lord. It is therefore prudent for a judge not to exercise discretion to allow judicial interference beyond the procedure established under the enactment. This power needs to be exercised in exceptional rarity where one party is left remediless under the statute or a clear bad faith shown by one of the parties. But this high standard set by this court in terms of legislative intention.
Question that whether your writ petition was maintainable or not.
Yes, madam. No, second, so far as the amendment is concerned, madam, you would see the case of Tata Sons Private Limited, the next judgment, madam, versus Siva Industries, page 10, para 25, madam. But this was a case relating to international arbitration.
Yes.
When the Honorable Apex Court has held, after the amendment, section 29A1 stipulates that the award in terms in matters other than international commercial arbitration shall be made by the arbitral tribunal within a period of 12 months from the date of completion of the proceedings under section 23(4). The expression in matters other than an international commercial arbitration makes it abundantly clear that the timeline of 12 months, which is stipulated in the substantive part of section 29A as amended, does not apply to international commercial arbitration. This further reaffirms the proviso of section 29A, which stipulates that the award in the matter of international commercial arbitration may be made as expeditiously as possible and that an endeavor may be made to dispose of the matter within a period of 12 months from the date of completion. The expression as expeditious as possible, coupled with the expression endeavor may be made, demonstrate that the intent of the parliament is that the period of 12 months for making the award is not mandatory in the case of international commercial arbitration. In an international commercial arbitration, the arbitral award is required to endeavor
that is, make an effort to render the arbitral award within a period of 12 months or in a timely manner. In domestic arbitration, section 29A1 stipulates a mandatory period of 12 months for the arbitrator to render the arbitral award. So therefore, my lord, so far as domestic arbitration is concerned, section 23, read with section 29, is mandatory in nature, my lord.
Yes.
You have to see the next judgment. That is a
No, what is how are you applying this present circumstances? Because subsection 3 of section 23 also defines that should not be the amendment should not be the instrument to delay the proceeding.
That's right.
Right. But that was taken care of by the arbitrator, and thereafter the amendment was allowed. How the factor of delay has any relevance in the present context?
My lord, my respectful submission is that after the respondent is called upon to adduce his evidence, evidence in the affidavit is filed. But his case was that I purchased material from X. But can he now come out with a different plea that no, I never purchased material from X?
Is subject of the decision by the arbitrator.
Well, in fact,
how it is relates to that.
Well, a valid defense is accrued in my favor. Well, I had demolished its case that no, you not purchased material from X.
These facts remain the same.
Well, now, all my questions and
the papers that you submit as evidence before the arbitrator. How this court can be governed? Only on the aspect that the amendment is sought in such a that suppose is the flagrant of the proceeding, arbitral proceeding.
That's right.
You may apprehend that this will again continue for the 6 months and so on in view of the section 29(1)(a) as amended. The arbitrator should not permit the amendment because ultimately it's caused delay to the proceeding. That was your plea before the arbitrator. But so we are not entertaining this.
My plea before the arbitrator was first, my lord, that the amendment sought for is going to change the nature and character. My lord, over here, the nature and character is completely being changed, my lord. But how is it permissible, my lord? Initially, he relies on a particular document saying that
it is open to the arbitrator. You file your objection or counterclaim, whatever you can file. And I humbly remind you, this arbitration reference of the dispute decision is not a suit.
That's right, my lord.
That periphery is completely different. Because we leave this in the hand of that to raise their claims, right? Because even the arbitrator doesn't know before the claim statement is filed before him exactly how and in what way the dispute will be placed before him. So the question of the changing the character is very flexible in arbitration proceedings.
Well, in fact, my lord,
you raised that it was not the dispute.
Well, we raised the objection that has been removed, my lord.
Because before going to the arbitrator, they filed a notice of demand, I believe. Notice of demand.
Yes, my lord.
So you show that this is not the part of the notice of demand, so the arbitrator cannot arbitrate this matter. Simply go there and raise this question.
Well, all these points were in fact raised in the objection.
Stage of amendment, I think that would not be just
Your lordships have held that so far, although the rigors of Evidence Act and the CPC is not applicable to arbitration,
yes,
even my lords have held that the sustenance from the fundamental principles underlying the CPC is applicable. So therefore, my lord, Order 6 was
principle of the nature of justice we are following. That is why now you see that there is a lot of judgment has come under section 34. The principle of natural justice will be lived also in a very narrowed manner. Unless the big prejudice is shown, the objection can also be diluted out. So I don't think that you should press this matter here. If you want to, then we will pass an order on merit.
One more judgment, my lord,
not difficulty, but the two judgments you have referred nothing to do with the amendment issue.
You'll have to see, my lord, the next judgment is at Australian Infrastructure Finance Limited at flag mark 4, my lord.
Flag mark 4, okay.
Paragraph 15. Paragraph 15, my lord, at page 6. When section 19 of the Act provides for determination of rules of procedure, subclause 1 of section 19 provides...
You are referring to
paragraph 15, my lord. I'm sorry, my lord. Paragraph 15. At page 6.
Yes.
Well, Section 19 of the Act provides for determination of rules of procedure. Subclause 1 of Section 19 provides that the arbitral tribunal shall not be bound by the Code of Civil Procedure 1908 or the Indian Evidence Act. The words arbitral tribunal shall not be bound are words of amplitude and not of restriction. These words do not prohibit the arbitral tribunal from drawing sustenance from the fundamental principles underlying the Code of Civil Procedure or the Indian Evidence Act, but the tribunal is not bound to observe the provisions of the code with all its rigor. As per subclause 2 of Section 19, the parties are free to agree on the procedure. So therefore, the fundamental principles underlying the CPC is applicable.
This is why that I am telling you this example. How? Because we want this is the first proceeding because arbitration is taken as the alternative remedy for deciding the dispute. I'll just make a comparison with the Family Courts Act. You'll find the almost similar order are employed in the Family Courts Act. That as far as practicable. How this phrase means as far as practicable. They need an outline of the procedural principles. They say take it from there, but not all with rigors. It depends how the tribunal or the family court for that matter will take their process forward. Only the important factor is that the parties, in whatever way, they should not be prejudiced. They should have the right of representation properly. That is the maximum thing that has to be protected under this provision. So I do not know if you can, then the amendment issue is there. And it is provided under Section 23, subsection 3. And I don't think that is a very ambiguous provision that requires interpretation. Is given that it is the only arbitrator who will be decide whether the amendment will be given. And another phrase has been added, whether it will cause the delay or not. That aspect has to be considered by the arbitrator. Ultimately, deliver the award within a time frame in view of the amendment has been carried out in the Arbitration Act.
But here is a question of pure delay, my lord. But at what stage, my lord?
Arbitrator says it will not cause delay. Now it is getting delayed because you are coming to the High Court and no, we will not interfere, Mr. Roy. We are not satisfied. These are the things we should interfere. So, because this 226 is we have to exercise circumspect so far the arbitration is there. We can only use when there will be the failure of justice. Otherwise, we will not entertain.
But at least, my lord, the depositions, my lord, is very clear from the depositions, the cross-examination of these respondents.
These are on record.
But everything was demolished, my lord.
No, the fact that these things are not getting obliterated. These things are on record.
But now it will result in the deed of proceeding, my lord. Now they have different agreements. First they say that
deed of proceeding.
But first they say that
no, they will be given the opportunity to lead evidence regarding the new claim or the new
again fresh, my lord, now is not the obliterated. Statement not only for the last, my lord.
Yes,
amendment application, my lord. You know, you would see, my lord, I'm so sorry, but my lords. My lord, that the amendment petition finds me at page 193, my lord.
Yes.
But initially they said that we had purchased it from SR India Steel Limited. As a consequence, we sustained a loss of 3.6 crores.
Would you admit these are the part of the records?
Yes, my lord.
Even if they now use the additional affidavits, even the arbitrator cannot obliterate that evidence. There is no law in our country that the evidence can be obliterated by way of amendment. Rather, they will be in trouble because they have already had evidence. The record of evidence is very much there. Now, if they just introduce a different set of evidence, their credibility will be at stake before the arbitrator. Just think over that. I think don't press this because I don't find any information in the order of the learned single judge.
Well, one of the amendment which they're seeking now, that no, we never bought it from X. That was a mistake committed on our part.
Whatever.
All through section 11, they maintained that we bought it from X. Yes. Now they're saying that no, we have purchased materials not only X, but a number of sellers, my lord.
Yes.
That is the amendment which they have sought for. Now my cross-examination, my lord, all my questions have been open.
You have stated in your petition also, in the written petition, that evidence of this claimant
yes, my lord,
has already been recorded.
That's right, my lord.
All right.
And now again, they would come with a different set of
I don't think that principle will apply to the arbitration proceeding. Because the amendment provision has been very clearly carved out an opportunity for either of the parties if they want to change their claim another thing.
But in support of the new claim now, again, they want to come to the dock, my lord.
Exactly. You can claim that it has to be completed within the stipulated time. That is the only thing you can place there.
But you know, one of the fact that it can be extended by another 6 months.
No,
my lord.
no,
There is ample of time for them to complete the case, my lord.
No.
And
the last you cannot take. Let the matter be left to the arbitrator.
I leave it to your lordship. My request the lord to pass a order.
By means of this retake, the intercourt appeal, the order dated, what is the date of the order? It is blurred.
27/7/2023, my lord.
Delivered in WPC number 16370 of 2023 by the learned single judge has been challenged. Mr. R. Rai and counsel has appeared for the appellant. So according to Mr. Rai, the amendment that has been sought by the claimant under subsection 3 of section 23 of the Arbitration and Conciliation Act 1996 as amended could not have been permitted by the arbitrator, as by the said amendment the claimant has entirely changed the factual basis of his case. Earlier, he had stated that he has purchased the coal. He purchased coal,
but not iron ore pellets.
Iron ore
Pellets. Supposed to purchase, my lord. There was an agreement to purchase
from one seller, but by amendment, they have incorporated a series of sellers from whom they have purchased this iron ore pellets. According to Mr. Rai, this is a paradigm shift in the basis of the claim, and that has changed the character of the very claim itself. He has also stated that even in the notice of demand that was pressed before the matter was taken by the arbitrator, no such facts were disclosed to the present appellant, who is defending the claim of the respondent. Mr. Rai has also pointed out that on the basis of the material, on the basis of the claim statement, evidence for the claimant has been recorded. Even the cross-examination has been carried out by the present appellant. So, Mr. Rai has submitted that the rich appellant has demolished the claim of the claimant slash respondent. According to Mr. Rai, this amendment has been carried to cause serious prejudice to the proceeding. So, the learned civil judge has addressed that issue and observed that there is no contrary agreement between the parties regarding amendment or supplementing the pleadings. On perusal of the intent order, it doesn't appear there was a question of inappropriate delay in applying for the amendment. The order records contentions of the parties, and from it there is corroboration that the opposite parties slash respondent had sought to supply the omission in the circumstances, this does not appear to be a real case, but there should be judicial review. Says there will be no interference by the learned single judge. Being aggrieved by the said observation, the present appeal, as stated earlier, has been filed. Mr. Roy has relied a few decisions of the apex court, but with all humility, we say that those decisions doesn't it doesn't appear to be relevant in the present context. Finally, Mr. Royal and Council has stated that the fundamental principles of the Civil Procedure Code would apply in the proceeding before the arbitration. He has significantly referred a decision in Srei Infrastructure Finance Limited versus Staff Private Limited, judgment dated 29/2017 in Civil Appeal number 15036 of 2017. In the decision, Apex Court has held that Section 19 of the Act provides for the determination of the rules of procedure. Subclause 1 of Section 19 provides that the arbitral tribunal shall not be bound by the Code of Civil Procedure 1908 or the Indian Evidence Act 1872. The words, quote, arbitral tribunal shall not be bound, unquote, are the words of amplitude and not of a restriction. These words do not prohibit the arbitral tribunal from drawing sustenance from the fundamental principles underlying the Code of Civil Procedure of Indian Evidence Act, but the arbitral tribunal is not bound to observe the provisions of Code with all of its rigors. As per Clause 2 of Section 19, the parties are free to agree on the procedure to be followed by the arbitral tribunal in conducting its proceedings. Stop. The principles broadly can be adopted in the arbitration. Principles of Civil Procedure Code can broadly be applied in an arbitral proceeding when the parties have not determined the arbitral proceeding, determine the procedure of the arbitral proceeding. The said observation of the Supreme Court doesn't hold that the rigors of the Civil Procedure Code has to be applied in arbitral proceeding. What we have gathered from the submission of Mr. Royal and Counsel is that he wants to bring in the element of change in the character of the initial claim, having compared the same with the change in the nature and character of the suit. With all humility, we would like to say that these provisions of Section 19 of the Arbitration and Conciliation Act 1996 cannot be read in exclusion of Section 23 within bracket 3, which provides that unless otherwise agreed by the parties, comma, either party may amend or supplement his claim or defense during the course of the arbitral proceedings, unless the arbitral tribunal considers it inappropriate to allow the amendment or supplement having regard to the delay in making it. Stop. Therefore, the only consideration as the arbitral tribunal can make that whether the allowing this amendment will cause a delay in making it and ultimately frustrate the provisions of Section 29A of the Arbitration and Conciliation Act 1996, which provides the tribunal time limit for the arbitral award. Stop. When a civil judge has correctly observed that the issue of causing delay was never raised by the present appellant, his only contention was the change in the original claim. Stop. The Section 23 within bracket 3 of the Arbitration and Conciliation Act 1996 is a flexible provision. Until the arbitration ends, the arbitral tribunal or the arbitrator can apply that provision, allowing someone to correct their claim or make the change in the statement submitted before it. Of course, due regard to be there in allowing such amendment for the time limit as prescribed by Section 29A of the Arbitration and Conciliation Act 1996 as amended. Stop. We do not find there is any, the apprehension of the appellant is as any rightful basis that they will be seriously prejudiced because the disclosure they have made by way of their defense statement / counter claim or by way of the cross-examination they have carried out of the witnesses the adduced by the claimant stuff. The nature of the arbitration proceeding is that the arbitrator has the solemn duty to find out the truth between the claim and thereafter decide thereafter they frame the decision in the form of a word. Stop. Having regard all these aspects of the matter, we do not find any merit in this appeal, as the impugned order doesn't suffer from any infirmity. This appeal stands dismissed. Stop. Before parting at the record, we would observe that arbitral tribunal, as the arbitrator shall observe the time limit as provided by Section 29A of the Arbitration and Conciliation Act 1996. Go to the next case.
Item number 6. In item number 6, my lord.
Yes.
If your lordship kindly permits me, with due respect to my lord, senior my lord, in the present case, I am filing an application for intervention, my lord. My lord, many facts have been suppressed in the application. My lord, there is a decree passed in our favor saying that it is the private property of these interveners, my lord, and that has been confirmed in the appeal as well as by the Honorable High Court of Patna, my lord. Thereafter, a 41 application is pending from the Commissioner of Endowments, my lord. There an order has been passed not to construction, my lord. And that apart, my lord, in many other applications before this summer report, many orders have been passed not to construct, my lord.
Have you filed the intervention application?
I am filing the intervention application.
Not that you supply a copy first, all of the parties.
Yes, my lord. I have got the copies, my lord. I am supplying it.
We are fixing the matter on the 31st of August. Supply copies.
Yes, my lord. I am taking them. So, so that I can.
All right, I was asking.
I elected petition. I am for the petitioner. So that is WPC 431 of 2000.
Very, very serious allegation of suppression has been made by the council.
I am appealing. In that case, I have another petition, the collected petition. That watching of a glance the order.
We are not passing any order of the council today. You are Mr. Das, I think.
Lenka, madam, Mr. Lenka.
Your name
is the connected petition, madam.
Okay. You are is a 431.
431. 431.
And your intervention application has been filed in?
Because
which collection? There are two writ petitions.
In the PIL. In the PIL, I mean,
your good name, sir, please. Your name.
PK Mistral.
Mr. PK Mistral and Council has appeared and submitted that an intervention application is going to be filed by name one of the party?
By Debananda Goswami.
By one Debananda Goswami in the course of the day. Stuff. We direct Mr. Mistral and Council to supply copies of such application.
I have already supplied.
Mr. Mistral and Council has submitted that he has already supplied the copies of the said intervention application to the council of the parties. Also to Mr. Lenka.
Yes. He is appearing in the other case.
Yes, connected matter.
Yes.
Give a copy to him. You just supply a copy.
I am supplying.
A copy has also been, Mr. shall also supply a copy to Mr. N. Legal and counsel appearing for the petitioner in WTC number 431 of 2022. Let the matter be listed on 31st of August 2023. Meanwhile, the parties who are inclined to file any objection shall file the objection against the intervention application. Stop. Place the matter on 31st August. Then the next case, in view of the order passed in WTC.
Sir, in the next case, the Lordship would kindly permit me to.
Yes.
Sir, in the next matter, I'm appealing for the appeal partner 3, that's the trust code of that institution.
Yes.
So that's a case, the Lordship would kindly see. There are several notices in the list which are pertaining to the latest issued by the Commissioner and Assistant Commissioners also. Lastly, your Lordship would kindly find that there is an IA filed by legal heir of the petitioner for substitution. Kindly see, one second, Mr. Blanchard. Kindly see that. That's a technical aspect, which in my humble opinion should be allowed and records should be regularized so that your Lordship can hear it finally. Otherwise, again,
What is the application?
application the petitioner is dead. Legal motion is dead.
They filed for substitution.
They filed for substitution. That is Article 3, 9 of 2023. Madam.
Any objection?
No, there should not be any objection. Madam. That should be allowed.
This is an application for substitution of the sole petitioner who has passed away when death occurred.
Well, in fact, the death occurred on 22nd of August 2022, my lord. But wrongly I have mentioned it 22nd of January 2023. But in fact, 22nd of August 2022, my
22nd of August 2022. Leaving behind his wife, son, and daughter as the legal representative. There is no opposition against the prayer for substitution of the elders of the soul petitioner. Accordingly, we allow the substitution. The amended cost title shall be filed
within a week.
Showing the legal representative of the deceased petitioner as petitioners number 1A. No, petitions number 1, 2, and 3.
Let them.
1, 2, and 3. Also, instead of the petitioner, the word qualifying shall be petitioners. Mr. P.K. RATHO and counsel has appeared for.
But I'm appealing for the appeal partner. In fact, I'm instructed to appeal for appeal number 3, man.
Senate counsel. Who is assisting you?
Mr. Basantia.
Mr.
P.K. Basantia.
Mr. P.K. Basantia and counsel. Appearing on instruction of respondent number 3. You have not filed the Vakalatnama.
No, Vakalatnama is there.
All right. It's already estimated such and such. There is a defeat in both the petitions. First one, 13, 19, 22. The defects. This is the defects number 13, 19, and 22. Who is appearing to the first case for the petitioner? Who is appearing in the first public interest litigation for you have Mr. Das. Mr. Das, there is some defects. You remove the defects by the next date. All right, by 31st, the matter will be taken up again. You remove the defects by that time. I'm taking the defect number 13, 19, and 22. The defects is identified by the registry shall be removed by the next date. Mr. Just in first as does your counsel is appeared for the petition. All right.
19394. You are 2023. I am appearing for the state we have filed a counter affidavit on behalf of the tourism department on, your Lordship may kindly note it, on 19th July 2023. Your Lordship may kindly note that I have sought copy on
DK Martin on it.
OP2, my lord, OP2. On 19th July 2020.
Number 2 has stated that the said opposite party has already filed their counter affidavit.
On 19th July 2020.
Already filed. 19th July is there. No, on 20th July 2023.
I beg your
20th July.
I'm sorry.
I beg your apology, my lord. My lord, I have got a difficulty on 31st. Can it be on fast, my lord?
Already, first of September.
Okay, sir.
Change the date from 1st of September.
My lord, another connected matter.
Oh no, 1st of September, it's a Friday. It cannot be.
The Monday, my lord, next Monday.
Next Monday, also a lot of matters are there, no? Huh? How many? 11th of September, this matter will come on 11th of September.
In the connected itself, another connected matter WPC number 15641 of 2023.
No, my lord, that is a matter related to demarcation, my lord.
Connected matter connecting. That may be.
All right, let us see. Just in the item number 6, with the date mentioned on Bristol services, along with WPC
number 15641 2020.
It's a single judge matter. Single judge.
Connected matter.
That is single judge matter, my lord.
we just on the day remind us.
In an interim order,
For the next.
Item number 7.
I have another question. On that day, at 2 p.m. is also fixed time.
2 p.m. is a slot. It's request to be auctioning now.
May not reach.
So we are not going to do that. It will come.
Very costly slot.
Yes.
My lord, in this case, may I submit one thing. There is an interstate dispute between trust board, some heritage claiming to be, but in the meanwhile, the government of Orissa has sanctioned a substantial amount and administrative approval has already been made for development of that particular institution. And I think for their interstate dispute, the developmental work should not be suspended. That is only right. It will be decided by the these developmental works are being constructed by OPDC.
Because there is a problem, Mr. A competent civil court has passed a decree declaring
Yes, sir.
they are the private road property.
Whoso, just a minute, whosoever will be the owner, he will enjoy the property.
How the government can invest?
It's a demand of the Gandhi, it's a.
We are not making the final comment. Let us on this.
But this is the affidavit of the state government.
Oh, no, we understand state has already sanctioned some huge amount
for development of that particular institution.
Parties can be present on the next date. Those who can take a stand in the courtroom.
Person
Parties means
I have represented the trust board.
So you are authorized to take decision.
Right, or the collector or Tahsildar.
I'm thinking that who filed the intervention application, tell him to appear on 11th.
Let me
One try to mediate the matter because if it is
Hit case for
property is good, but you have acknowledged that there is some religious shrine is there.
It's not very famous religious institution.
It's a 16th century institution, my lord.
That is
a public religious institution already held by the Supreme Court and statement, my lord. There is absolutely such declaration.
That is
I am committed
to faith come together on a consensus so that the area can be developed.
Because the interim order passed by this the connected matter,
the whole development work has been stopped.
Yes. That is why I'm asking the parties to come so that we are taking a decision.
So let us try to finish on that. Order was passed, proceeding where it will be declared whether it is a public institution or a private institution is pending. The judgment is reserved. And while passing the interim order, your lordship was pleased to direct the learned additional commissioner to give a report by which date he can deliver the judgment. In the meantime, more than a year has passed. That has not been decided. Unless that is decided, my lord,
whether the report has been submitted.
that is there. But the fact, even that, continue in the connected. That is the
In the connected matter, this all right. In the next in 431. 431 in view of the order that placed the matter, interim order, not to which it continued in the district. Two line orders.
Item 7.
Item 7 policy. See, this is a case management limited prayer reform nursing. My representation is annexed to 2 machines that is pending for opposite fund number 2, which is collective valuation. That regarding
What is there in the come to the page? In the 10. You have not given the translation of this newspaper.
Page 10 is the
Newspaper report.
Newspaper report has been that published by so that the misappropriation has been made by the some other Sarpanch and JE and other.
All right. I got it. All right. And now your representation, what you have demanded by this representation?
Representation is a page 12 manusi. That has been
Sarpanch, GRS and GE are getting the bills.
Page 4, I have written all the things. Page 4, that is in English means that is it.
Page 4.
Page 4. Page 4. Clause 4.2. The matter stood there showing the money has been sanctioned on. That has been all things has been written also.
Is appearing, Mr. Mehra, that this is completely this is action deviating from the very original scheme of the NGM and rigor.
My lord, it's just merely bald allegations have been made on the basis of a newspaper report.
The collector is the nodal officer in the district.
Your lordship.
So let him inquire and take the appropriate action.
Let him consider the representation. Your lordship.
All right. But Mr. PC Jana, counsel.
PC Das.
PC Das, counsel. Appearing for the petitioner. This is a public interest litigation. Filed by the petitioner, who is this public spirited citizen, on the allegation that the work for which the money has been sanctioned from the NREGS scheme are being carried out by hiring the personals who are not job card holders, and the sum of rupees 1,30,000 has been paid to them. Stop. A report in this regard has been published in a newspaper called Prameo under the caption of graving of rupees 33 lakhs without executing the work. Stop. After coming across all this information, the petitioner filed a representation on 17/6/2023, which is an exception to this writ petition, urging the collector and district magistrate Balasore. Is Balasore?
Collector Balasore. Balesur.
Stop. For remedial measure, the solitary prayer that has been made in this PIL is to direct the opposite party number 2, the collector and district magistrate Baleshwar, to consider their representation and to take appropriate action. Stop. We dispose of this petition directing the opposite party number 2 to make an inquiry in the allegations made by the petitioner. And if there is any irregularity, he shall take appropriate action. So we further observe that he should seriously inquire whether the personnel who are not job card holders are being given jobs for a NEREGS work. So, a copy of this order be furnished to Mr. Behra. A. Behra and Council has appeared for the opposite parties number 1 and 2. Additional standing council, yes. I don't give any time limit there, as I'm telling you, he'll encourage.
And time limit is a
We have done it. All right.
My prayer is timing.
The entire exercise shall be completed within a period of 4 months from the date when a copy of this order will be received by the opposite party number 2.
4 months.
4. Collector?
Yes, 4 months.
Mileage.
4 months.
4 months. Mileage.
Yes. Next.
Obligations. Item number 9.
May I please be honest? The petitioner before your lordships is a pioneer, my lord, in management of environmental management, and he has an expertise in dealing with hazardous materials, my lords. And keeping his expertise in view, the nodal agency IDCO entered into a concession agreement which is at Annexure 3.
It is item number 9.
9 months.
I'm sorry. I'm sorry.
Who is assisting you, Mr. Hazra?
Mr. R. Satpathy and Mr. Hazra, D. Hazra. R. Satpathy and Mr. Hazra.
Lordship, I'm here through VC.
Mr. Satpathy is on VC.
All right, no, Hazra is there.
Mr. Hazra is there. And both of them assisting me.
Yes.
All right.
So, Lords, keeping his expertise in view, Lords, and the Honorable Supreme Court's judgments, a concession agreement was entered into by the petitioner with IDCO on 22nd of December 2007, which your Lordship would get it at Annexure 3, page 71 if your Lordship's brief, Lords.
Yes.
And if your Lordship would kindly turn to page 72, the third paragraph, they say how this particular concession agreement was entered into. They refer to the Hazardous Waste Management and Handling Rules 1989, the Honorable Supreme Court's directions, and they say that since they are the nodal agencies, they are entering into a concession agreement with the petitioner. Keeping this concession agreement in view, notes, right? Annexure 5 at page 96. Lordship got it?
Yes.
IDCO allows, if your Lordship would turn to the relevant portion, we will not take to the whole of this. It begins with allotment of government land measuring 63 acres, 63.30 acres in village Lakhanpur for establishment of industries and the setting up of a common integrated hazardous waste treatment, storage and disposal facility at village Lakhanpur, Tehsil so-and-so, Jharsuguda district notes. And if your Lordship would straight away turn to annexure, page 101 of the same annexure, the area of 63.30 acres was given to the petitioner notes. At that stage, Lords, I also approached the state pollution control authorities And the state pollution control authorities, my lords, even though they fixed 3 dates for a public hearing, a public hearing could not take place because of the COVID-19 situation.
Yes.
And the public hearing, application for public hearing is still pending with the authorities, my lords. While the matter stood thus, my lords, I came to learn in January 2023 that opposite party number 8, who has not yet been allotted a parcel of land, makes an application straight away to the State Pollution Control Board for allotment of 63 acres. And then, my lords, basing on that, my lords, a public hearing is now supposed to be conducted. And the what should be kind of see the public hearing.
How the State Pollution Control Board can make allotment of land?
No, no, they are not allotting. What they not,
They are holding the public.
they are holding the public meeting notes. They are actually kindly come to answer 28.308 notes.
Who is appearing for the Pollution Control Board? Any standing council?
The private councils, they are engaging their own.
Oh,
They
okay.
have a panel, I think.
Yes.
They have a panel. Who is there?
And now, my lords, the land is not demarcated. So far as the opposite party number 8 is concerned, the demarcation petition is still pending with the Tahsildar Jharsuguda. State Pollution Control Board goes forward and calls for a public meeting.
SIA we are appealing. For SIA we are appealing.
For the central authorities. So my only contention is twofold. One, my lord, is a site location, my lords. And so far as the memorandum is concerned, my lords, the site location, if your lordship would kindly see, my lords, if your lordship would kindly turn to page.
Mr. Muduli, that we take up the matter of 31st of August. We'll stay the further hearing by the State Pollution Control Board. You take an instruction from the Tahsildar Jharsuguda, how much time you take for demarcation proceeding?
I'm not concerned with the demarcation proceeding. So
We are concerned.
I'm sorry, I'm greatly.
Because I do not know what is the land of the other, this, your,
Party number 8.
this is claiming who.
But at least till then, let no public hearing be conducted.
This is what I have proposed.
No. I'm sorry.
Let the public, because since public notice has already been issued, let the hearing be concluded,
No,
but it shall not be given effect to.
But once,
Kept in a seal cover.
once a public hearing,
Public hearing is there, the public opinion is formed, it will complicate in the process. Let the public hearing be deferred for some time. We want only the Tahsildar's report. Because clearly there's a government, this letter of intent shows a certain amount of land they have already for the project
Public hearing
in
is
favor of the petitioner. They have
after tomorrow.
identified. All right, we are staying this subsequent date. That is a shorter date he was giving on 31st of August. All right. Our Mr. Call and Council, Senate Council is stated by Mr.
R. Satpathy, R. Satpathy and Mr. D. Hazra.
R.
The hearing is scheduled to be commenced to.
Day after tomorrow.
Day after tomorrow, that is our anxiety. We don't like to complicate the matter.
This was issued on 19/7.
Oh, they are coming now because they are bringing a very serious issue. Try to understand. In all expectation, villager is opposed his project more. I'm telling you that. But it is required for the better public good. Mr. Accordance, state by such appealing to the petition now. It has been stated by Mr. Paul, Land Council, that in terms of the Supreme Court order, an understanding has been entered into by the. What is your understanding that?
That's a page, it begins at page 71, Annex 3.
That the agreement has been entered into between the Orissa Industrial Infrastructure Development Corporation and
And the petitioner notes.
Ramkey and Engineers Limited
Petitioner's former name is Ramkey.
for setting up of
Integrated hazardous waste treatment.
That is, what is the government's order? Letters?
Letter number annexure 5 at page 96, my lords. The allotment letter. For setting up of a
For setting up of
in the subject matter, my lords, common integrated hazardous waste treatment.
right. Common integrated common hazardous waste treatment storage and disposal facility at Lakhanpur, Jharsuguda district. Step. And where is this land?
101, my lord, at page 101 of the same annexure, my lords.
And for this purpose, an area of land measuring 6.30 acres.
63.
63.30 acres, 63 acres. From plot number 1351/56662, Khata number 277, within first AIM, close the bracket of the Moja of the village Lakhampur has been earmarked for the petitioner. The public hearing, according to Mr. Cole and his senior counsel, could not take place for the intervening pandemic situation. So in the meanwhile, the opposite party number 8, namely Messrs. Utkal Innovation, has come up with a similar project.
It's a similar project in a different place.
Similar project in a different place.
Which again is within the restricted zone.
Where is their this?
No, that particular place, my lord, your lordship would turn to page 308.
Does it come up with this similar project?
308 at annexure 20. It's Moja Paramanpur. Your lordship will get it, my lords, at 3 lines from the bottom of the first paragraph.
Lordship, it's Parmanpur, Kola, Pera, Jharsuguda.
At Moja Paramanpur,
in the district of
plot number 326/3685 within bracket P, Khata number 265 within bracket RAKHIT. It is Khatit or Patit? Khatit. Rakit. Stop. The petitioner only apprehension is that whether their project has been abandoned by the Orissa, this is called Orissa Infrastructure Development Authority. Infrastructure Development Corporation or not.
It's Orissa Industrial Infrastructure Development
Corporation or not. As we understand, this root of this apprehension is that whether 2 such facilities are required in the same district or not. So, in this regard, we need to have the response of the opposite party number 5 in particular. That apart, a report shall be filed by the Tahsildar Jharsuguda whether the land as identified by the petitioner has been surveyed and demarcated.
Opposite part number 8. Because the demarcation of the opposite party number 8's application, my lords, they have been gochered land throughout the entire area. So that has been given for
that. We are not looking at because we understand this. You should have a complaint before the government. Stop. Identified or not? Stop. Since the two projects supposed to come out in the two different locations to avoid any complication in the project, we direct the State Pollution Control Board, Orissa State Pollution Control Board, opposite party number 4, not to hold a public hearing before the next date. Stop. We would stop. Issue notice returnable on 31st of August 2023. Petitioner shall take steps for service of notice on Mr. Pari, are you representing the Central Pollution Control Board? Yes.
P6 and 7.
On yes. P
1, 3 and 6.
7.
7
No, this is a separate authority. I think notice should go to them.
I think I learned it.
State, can you represent Mr. Mudali, these 6 and 7 also?
No.
So take steps for service of notice.
6, my lord, scenario will appear.
6 year will be appearing. It is state environmental impact assessment.
That is MOE, part of the MOE.
All right. All right. On 7 and 8, opposite party number 7 and 8 by speed post with AD in the course of the day. As Mr. P.K. Mudali, National Government Advocate, appears for the opposite party number 2.
Only 2.
Opposite party number 2. And Mr. P.K. Pari, Deputy Solicitor General of India, appears for the opposite parties number 1, 3, 4. By 4 also notice should go now. 4, 5.
4 and 5 notices to
This I will appear in 1, 3 and 6.
Notice 4, 5. And 6 and 7. You are appearing for 1, 3, and 6 and 7.
Yes.
All right.
7, my Nasim issue notice because I don't have
All right.
idea.
6 and then 7 also including the product the notice. 2 extra copies. It is supplied by Mr. Hazira. You just supply. Land Council appearing to the petitioner to Mr. P.K. Paril, Deputy Solicitor General of India, in the course of the day. So till next day, just ask the Pollution Control Board. Notice will be going from here.
Collective also. The collective Jharsuguda should also be informed.
No, you are not made collector Jharsuguda party. In Mr. Mudali, just you inform to the Pollution Control Board informally. Let them ask there is an order not to hold this public hearing till the next day, the 31st of August. All right.
May I pray for an urgent copy?
Urgent certified copy.
Copy be supplied so that I can communicate to the police.
All right. A free copy of this order is applied to Mr. Hazira, responsible petitioner, and Mr. P.K. Mudali, Additional Government Advocate, in the course of the day. Type it first. Huh? All right.
Obliged, Your Lordship.
Item number 10.
Yes, next.
Item 10. May I please, Your Lordship? This relates to
My lord, I have challenged the validity of the statute, my lord, where the fact of the case is like this, my lord. At Annexure 1, my lord, certain posts, 406 posts were posts of dental surgeons were created by state of Orissa, which were to be posted at peripheral health institutions, my lord. Subsequently, my lord would find at Annexure page 17, here, my lord, when advertisement was issued, may I draw my lord's attention directly to page 19, my lord.
It was issued on April 2023. You are in the month of August now.
My lord.
No, we had changed.
My lord, here I had approached the Honorable Single Judge, appreciating all the facts. May I place the order? I have annexed that also. The Honorable Single Judge said that as this relates to the 309 rule, he cannot
understand why it has come to the decision. He understand. Yes.
My lord, here I have challenged.
No, because of you don't pray for the stay order, then we are.
My lord,
yes, don't stay because
now my lord,
April order, April advert.
My process of selection, I don't want to stand in the way of process of selection. The selection process now, the rating test also has not commenced till now. But the whatever the prayer the petitioners had here, my lord, that will also be allowed. That can be incorporated in that selection process. Because what I pray is that the state of the students, there are 4,000 registered students, dentists of residents of Orissa. Available in Orissa, only 400, around 400 posts of government posts are filled up. The rest are without job. And what they have done is that through this rule, they are opening gates for outside students. Whereas the same department has number of rules I have annexed here, where they have this, they give this preference to students of Orissa. Even in medical education, where the medical education service rules, the lecturers, assistant professors, postings.
I think you know the decision of the Supreme Court in Maratha reservation case. It's a long order. Domicile reservation has not been approved by the apex court.
Here, my lord, directly I am not asking for what
this wants a preference.
And they have been giving me. There is a rule that that is compulsory. What they said that once you have to gain that documents and the certificate after you join the service.
No, it's obvious. In the All India service, it is there. Within 6 months, they have to gain a certificate.
Here in all rules of the same department, health and family welfare department, so that you have to have it before you have this. Secondly, registration in Orissa register. Once a dentist has to get registered in Orissa Dental Council, my lord. And all other departments.
That is mandatory.
Thirdly, my lord, another rule I have challenged here, my lord, that is also affecting.
That is serious.
State government.
If you are going to appoint a dentist and he's not under you this state role of the dentist, this is mandatory role.
Your lordship,
how can you appoint someone like?
Your lordship, the proviso reads, provided that if a candidate outside the state of Orissa has not registered his name under the Orissa Dental Council as per the provision of section 34, he shall get himself registered before issuance of appointment order.
Yes. They don't have this in all other appointments. And they say that you have to get registered before you apply for the post. Once a person will be eligible, once he has a registration from Orissa Council.
Basically, this is a policy matter, and I say so far the domicile reservation is concerned.
My lord.
This is now a settled issue.
My lord. But the same department, I have annexed all the advertisement that
you tell us whether this court can rewrite the rule under its Article 226 so that the rule suits this petitioner's interest. We cannot do. That is why we say that file an application before the competent authority. They will reconsider the issue And if anything is to be changed, they will change it, not the court.
I have challenged the virus of those rules, my lord.
And virus, what is the ground of challenging the virus of the rule? Tell us.
My lord, here the same department has state of rules different than
virus. That is not a virus.
My
this is clearly there's a rule is unconstitutional.
My lord.
And the parameters are well laid.
Here, my lord, place, my lord, this means they have this rule, but they are by inserting this provision, the rule itself becomes infectious.
How?
Because
how? That is why I'm questioning you. How?
My lord, these posts are in peripheral. All these
the person coming from the outside will not serve the periphery of the Orissa. For 6 months only.
6 months also. Yeah. They have and all these they will be working in all peripheral places where even in medical education, I have annexed that rule also. For being appointed in a medical college, an assistant professor, he has to they are giving this preference. The state students
policy again and again. I'm telling you, giving some preference is a matter of policy. If you challenge the constitutional rules, show us how it is ultra-bias. Show us how it is.
This rule is not in consonance with all of this same department of the same state.
State is not restricted that when they are framing the rules that should be in conformity or similar to other rules that are already in existence. The sub-legislative power is ingrained in this provision itself, proviso to Article 309 of the Constitution. And I don't think, because we can give you the opportunity to file a representation before the state, raising all the
the only single judge passed that order, elaborative order, asking us to file the representation. We have filed, no response. They have not given any response, and that will not solve the problem. Because
that is not so. The court will not go to write a rule for the state government. Can the court write a rule?
My lord, may observing another serious matter involved in this case, the third rule which I challenge here is that is also affecting the state government and the students of Orissa. What they have done here is that there will be number of tests, 9 number of tests advertised. OPSC will recommend only 9 number of tests. I think there should be a waiting list. Why? The practical problem that arises out of it is that if there is the 2 tests from Cooperative District is advertised, commonly they apply for it, they get selected, they get the preference to support the candidates for Orissa. They take an attempt to take
why you are taking the trouble of the government on your shoulder?
To get selection, well, if I am interested for a post in Cooperative and I am at 4th position, 3 posts are advertised. These 3 posts, those who are selected, they would like to join that will be but I the next person will not be given a chance to get up.
Say that give to the next person.
That
what is your vested right? Being in the wait panel.
Waiting list is not available itself.
That is why the government has just completely excluded this keeping the wet panel, because it creates a lot of problems sometimes. Some people start thinking of that as I have a right if for any reason one of the person doesn't accept this appointment or resigns from the post. It's not that. So this is not your right, Mr. Counsel. This is only for the convenience of the government. Government keeps it so that the entire process of the selection is not required to replicate. That's the whole purpose. What is your right to claim a wet panel?
Because in fact that happens. The posts are lying vacant.
That. We also know that with the keeping the wet panel also sometimes what happens. That after 7 months someone, and in the meantime in the open market, there are more eligible candidates are available. They will not get the opportunity.
For that only at the Koraput Medical College, there have been 5 advertisements, but still the contractual employees are continuing because no regular employee is interested to join there.
No.
And I am also,
If you already go and apply there, whenever the next time advertisement will
no, that is centrally like that Odisha Medical Education Cadre, they float advertisement commonly.
That is obvious.
That's why
I don't think there is any fire in this case. We are closing it.
may I pray, my lord, may direct government to take a decision on this.
Where is the direction of the single judge?
My lord, that is at page 80, my lord.
Okay. Do you have any instruction, Mr. Behra, regarding whether the direction of the learned single judge has been complied or not?
No, Your Lordship, I have no instruction on that.
You are Mr. Mishra.
My lord.
Heard Mr. Abhijit Mishra, the counsel, appearing for the petition. By means of this petition, the petitioner has challenged clause 6 within bracket 5, clause 7 within bracket small c, close the bracket, within bracket small Roman 4, close it, and clause 7e, small e, close the bracket of Orissa Medical Services, within bracket method of recruitment and condition of service of dental surgeons, close the bracket rules 2022. Stop. It has been further asked by this petition to cause the consequential advertisement number 2 of 2023-2024 dated 24/2023 for recruitment to the post of the dental surgeon in group A, capital A, within the GR of Odisha Medical Service within the dental cadre under Health and Family Welfare Department. Stop. The advertisement is at Annexure 4 to the petition. Stop. Mr. Mishra Learning Counsel, appearing for the petitioner, has stated that those clauses which are under challenge have been creating serious bottleneck for the aspiring candidates from the state of Orissa. Though it has not been spelled out, the petitioner is challenging the said rules for ensuring the preference of the candidates having qualification on the basis of their domicile. Stop. Mr. Mishra has fairly submitted that the purpose of filing in the writ petition is that about more than 400 posts of dental surgeon have been created for purpose of extending the service to the periphery of the state, where for the citizens it is very difficult to get the service of the dentist.
400, second phase, another 200, 600.
600 posts, okay. According to Mr. Mishra, that unless a dentist have the knowledge of reading and speaking Oriya, he will not be able to serve the people properly. He has brought the example from the other similar rules where it has been made mandatory the person who is applying for the post shall have the functional knowledge of Oriya. But in the present rule, there is no such provisions to make the dentist will be posted after selection in the rural segment of the Odisha. As such, the minister has submitted that a clause should have been incorporated in the rules by providing that the dentist having all qualification shall be given preference over the candidates from outside, because it is understood that those who are from Orissa are adept in speaking and writing the Oriya stuff. That apart, it has been stated by Mr. Mishra the Learned Council that there is no dearth of the dentist registered with the Dental Council of Orissa.
More than 4,000 are there.
For filling up those posts. As such, inviting the person from outside will serve no purpose at all. As such, this absence of such rule makes the present rule unreasonable. So, Mr. Minister has fairly submitted that earlier the petitioner approached the where is the judgment?
Well, that is at page 80, my lord. 80, start from 84, my lord.
But a single judge of this court on a similar issue. So, and the said petition being WPC number 15694 of 2023, the learned single judge by the order dated 16/5/2023 has observed that
That are 11.
the petitioners, if they are so advised, may challenge the Rule 7C by filing a separate application on the ground that the proviso resolutions runs contrary to the proviso to Rule 7 in bracket C, in bracket small 1. So finally, the writ petition was disposed of court by granting liberty to approach the opposite party number 1 by filing a grievance petition along with supporting documents. In the event such grievance petition is filed by the petitioner, the opposite party number 1 shall do well to consider the same, keeping in view of the difficulties faced by the dental surgeons who are inside the state, and this court decides and takes such decision, and this court decides that the such decision, this court, the learned single judge has decided that the such decision shall be taken within a period of 4 weeks from the date when the petitioner shall file the opposite party number 1. Mr. Ministerial Learned Council has submitted that till now, even though the representation was filed in the line as indicated by the learned single judge, the opposite party number 1 has not taken any decision. At least such decision has not been communicated to the petitioners. Stop. The brief fact we would like to refer as the background of the above challenged. Stop. Rule 7, sub-rule C, then bracket small Roman 2 of Orissa medical services, service within bracket dental. This is a cadre service rules. What is the name of the rule?
Odisha Medical Services Method of Recruitment and Conditions of Service of Dental Surgeons Rules 2022, page 35, Merit. Page 35.
Orissa Medical Services, method of recruitment and condition of this in page Annexure 7. Within the method of recruitment and condition of service of dental surgeons, close the bracket, rules 2022. Provides the eligibility criteria for direct recruitment to the post of the dental surgeon. So, Rule 7 within bracket 1 within bracket C of the said rules clearly provides that the person who will be applying for the said post be able to read, write, and speak Oriya and must have passed middle school examination in Oriya as a language subject or pass the matriculation or equivalent examination with Oriya as medium of examination in non-language subject or passed in Oriya as language subject in the final examination of class 7 or above, or passed a test in Oriya in middle English school standard conducted by the School and Mass Education Department. Stop. But it has been further provided by a proviso below the clause C that if a candidate has not passed the middle school examination in Oriya as a language subject, he shall be required to pass the examination conducted by the Board of Secondary Education, Orissa, within 4 years of joining in the service, failing which no further increment shall be sanctioned, or will promotion to the will get promotion to the rank of Group A within the senior branch. Stop. Such deferment will continue unless the person appointed has passed the Oriya language test. So this has been changed now.
No, Malad. This is what I challenge.
Why you have challenged this?
Because Malad, a person from outside Odisha, he is allowed to
say his time.
Allowed for his time. Even if he doesn't pass also, then also only increment will be.
The grievance of the petitioner. The ground of the challenge of the petitioner is confined to the said proviso. For better appreciation, we reproduce the said proviso. Just this one, the proviso, just above D, there are 5-line proviso, page 38. You find there is a small D paragraph. Above that, there are 5 lines like this. Mr. Mishra has also stated that even the candidates who are not registered with the Orissa Dental Council are being provided opportunity are being given opportunity to get selected and appointed as the dental surgeon under the above cadres. Stop. Even a provision has been made that those persons who are coming from outside Orissa will get the opportunity to get themselves registered with the Orissa Dental Council under Section 34 of the Dentist Act 1948. Stop. On the basis of the said challenge, the advertisement dated 24/2023, Section 8 to the writ petition has been challenged. We have heard Mr. Mishra at length, but we do not find the challenge against those provisions of the rules are based on any ground either of otherwise the gross arbitrariness or being again any public policy as such. This purpose of this writ petition is apparent on the face of the record is that to create a reserve for the dentist from Orissa and not anyone, and not to allow anyone from outside Orissa to participate in the selection process. It is no more resulting here that the blanket reservation on the basis of domicile is an anathema to the constitutional principles. But as a matter of policy, and in order of getting meritorious and effective service, the state government can provide in the rules various additional requirement, such as a local language, knowledge of local language. Stop. And after reading of the provisions of the rule, we are convinced that aspect of the matter has been seriously considered by the state government at the time of framing the rules. As such, we do not find any sustainable ground to strike down those rules. So, as Mr. Mishra has pointed out that in terms of the order dated 26/5/2023 as delivered in WPC number 15694 of 2023, the opposite party number 1. The opposite party number 1 has not considered the representation filed by the petitioners. We would further direct the opposite party number 1 to take a call on the said representation within 30 days from today. Stop. At the time of considering the representation of the petitioners, if it is found that some more restriction is required to be imposed on the basis of the knowledge of the Oriya language, the authority shall do that. Still, as we have referred earlier, that for the service to the people in general in the periphery of the state, to give the better service to the people residing in the periphery of the state, the knowledge of Oriya is an essential condition of should be treated as the essential condition of the service. And the period as granted to the extent of 4 years is an unreasonably long period. Stop. Mr. Arnav Dehra, an additional standing counsel, has appeared for the opposite party number 1. Stop. As in respect to the challenge to the rule, opposite party number 2 doesn't have any role whatsoever, that we have not issued any notice on them. Only when the rules sought to be amended by the state, their opinion has to be taken in terms of the proviso to Article 309 of the Constitution. So accordingly, this petition stands disposed of. Declared.
11.
Yes.
May I please, your lordship? Let the petitioner is a bachelor in pharmacy certificate degree holder. The challenge the virus of the rule, my lord, the Odisha pharmacist method of recruitment and conditions of service rules 2019, my lord. The statute, the provision has been challenged, my lord. My lord, in the Annexure 3, page 24, my lord, the rule. In the schedule, my lord, the rule 10 describes the minimum educational qualification. Page 27 of the rule, my lord, of the running page 27. That has been prescribed the educational qualification of the candidate for the post of pharmacist as specified at column 4 of the schedule, my lord. And the schedule portion in the last page, my lord, page 31.
Yes.
The lordship may see the column 4, pharmacist, district cadre.
Yes.
Must have passed the +2 science examination under Council of Higher Secondary Education, Odisha equivalent, and diploma in pharmacy from government medical colleges and hospitals of the states, any other recognized private institutions duly approved by the AICT and examination conducted by the Odisha Pharmacy Board. But the main ground of the challenge of this schedule and along with the allied rules, my lord, the petitioner is a bachelor in pharmacy and
Bangalore.
bachelor in pharmacy, my lord.
Higher education is not being considered.
Yes, my lord. But that, your lordship may see the advertisement issued.
Have you got the decision of Justice Chandrachud in 2021?
22, my lord, the police or Shukla case.
2021, no.
22.
22.
My lord. That is exactly.
And one decision of Justice M.R. Shah is also there.
My lord. Your lordship may see that all over the state, all the state governments of the India, my lord, our country has framed the rule, and the bachelor in pharmacy and diploma in pharmacy are the minimum prescribed qualification for the post of pharmacist, my lord. I have given the all about 20 state governments advertisement and the central government's advertisement for the pharmacist. My lord, in our state, my lord, the Odisha people, Odisha sovereign staff selection advertises for annexure 4, 600 posts, where they would only allow the diploma in pharmacy candidates without allowing the participate to the degree holders. My lord, at the same time, the Odisha Staff Selection Commission issued advertisement by allowing the degree in diploma. And the CDMO in the Koraput also, my lord, prior to the rule, has allowed the degree in diploma. But the Odisha Sovereign Staff Selection, my lord, in consonance with the provisions of the improved provision of the rule, that is 10 and 11 and the schedule, my lord, we have not been allowed to participate, even though your lordship may see that it violates the Pharmacy Act 1948. Your lordship may see, I have categorically stated and the relevant rule, my lord, I have cited Annexure 7, page 58, Pharmacy Council of India. Your lordship may see, page 58.
Yes.
Clarification, it was issued by the Pharmacy Council of India to all Principal Secretary Health and technically all state governments, all state pharmacy councils. Clarification on minimum qualification for the post of pharmacist. The following are the registrable qualification under the Pharmacy Act 1948, provided they are obtained from an institution approved by the PCI for the purpose of registration: Diploma Pharma, B Pharma, Pharmacist, Pharma D. Please find here is the Annexure 1, notified by the Ministry of Health and Family Welfare, deciding that a person holding the pharmacist diploma D qualification being higher qualifications shall automatically become eligible for appointment to various posts, where a person holding diploma in pharmacy or bachelor in pharmacy or master in pharmacy is also eligible to be appointed. Next, my lord, 59, the Health and Family Welfare Ministry notification.
Yeah, Mr. Sahu.
My lord.
Mr. K.C. Saul and counsel appearing for the petition. By means of this writ petition, the virus of the Rule 10, 11 and column 4 of the schedule of the rule called Orissa Pharmacist Service within bracket method of recruitment and condition of service, close the bracket, rules 2019 have been challenged. According to Mr. Sahul and counsel, the person having degree in diploma is well considered to be registered as pharmacist by the Pharmacy Act 1948. But by the rule as challenged, the opposite parties have excluded the petitioner and similarly situated persons who have degree in pharmacy from consideration for selection to the post of the pharmacist. As a result, the petitioner was not allowed to participate in the selection process. Stop. According to Mr. Sahu, whether a pharmacist within the meaning of the Pharmacists Act 1948 can be excluded for having a higher degree in pharmacy. So, this provision under the said rule is grossly unreasonable, and it is against the it stands in contrast to Article 14 of the Constitution of India. And the rules as challenged are against the is unconstitutional and liable to be struck down. The issue rule returnable on 27th of September 2023. Since Mr. P. Behra, Additional Standing Counsel, appears and works notice for the opposite parties number 1, 2, and 3.
No, 3, Your Lordship, they have a separate count, separate. No, Odisha subordinated.
All right, 1, 2, 1 and 2.
Well, 3 is also government is appearing. Subordinate by government. Odisha staff selection by separate.
So you are not accepting for
1, 2, and 3, Your Lordship.
All right, it is for opposite parties number 1, 2, and 3. No formal notice is called for in respect of those opposite parties. But the petitioner shall take steps for service of notice on the opposite parties number 4 and 5.
My Lord, 4 and 4. My Lord, I will serve a copy. Manoj Kumar Pati, CGC, along with
Mr. Yes, sir. Also, sir, Mr. M. K. Poti, Political Counsel, has appeared for the opposite party number 4 and waived notice. The petitioner therefore shall take steps for service of notice on the opposite party number 5 only by registered speed post with it.
Council of India.
As a step shall be taken by tomorrow, considering the short return of date.
Item 12. My Lord, I have, sorry, my Lord. I have filed, because in the meantime, my Lord, the government has requisitioned for filling of 1,002 posts of pharmacists, and the Odisha Sovereign Staff Selection in their calendar also incorporated by the Annex 13 I have given to issue the advertisement. Those selections are already on hold because my line is one before the signature. That is already the ensuing, my Lord, the Odisha Sovereign Staff Selection, they have issued the calendar for making post recruitment. I have taken specific averment, my Lord, 1,002.
What is the last date was there for that application?
No, now in the bill stated that in the October 23, the August 23, the advertisement will be issued, and October 23, November 23,
all right.
It's 118.
This is an interlocutory applications filed with the 12258. Filed by the writ petitioner for staying the operation of the imperial provisions, i.e. Rule 10(11), column 4 of the schedule of the said rules. Stop. And this prayer has been made to stall the proceeding of recruitment to the post of pharmacist on the basis of the existing rules 2019. Stop. Mr. Arnav Behra and Additional Standing Counsel, having appeared for the state opposite parties, submitted that unless the rules are declared unconstitutional, state is bound to follow the extant rules. Stop. Be that as it may, we have heard Mr. Mishra, Abhijit Mishra, and counsel from the applicant, and is of the view that if any advertisement is published to launch the selection process before the writ petition is disposed of, the petitioner shall be allowed to participate in the process. But we make it absolutely clear this will not be treated as a staying the proceeding of the selection. Stop. Only the petitioner will be permitted to. Yes. No, MP Pothi. Mr. Pothi, your name has been reflected for the service, this Union of India.
Item 12.
May I please, Your Honor? Again, the petitioners of the villagers who have challenged the action of the state authorities in constructing a road over the Gochar land. Lordship may kindly have a glance to page 13, my lord, under annexure 2, the plot number 232 under khata number 198, the 1 acre 73 decimal, the kisam of the land is Gochar, my lord. Now, my lord, in order to facilitate the opposite parties 5 to 15, a road, they are trying to construct a road over the Gochar land and without following the due procedure of law, my lord.
Will take instruction or your lordship may direct the Tahsildar to examine the grievance of the petitioner and pass.
Already.
That because they have filed a representation before the Tahsildar,
So
that is available at page 31.
The road has been constructed already.
No, my lord, not constructed, they are trying.
Already. By means of this public interest litigation, the petitioner has asked this court to direct the opposite parties number 1 to 4 not to change the nature and character of the land under khata number 198, plot number 232, measuring an area of 1.73 acres under Moja Jantrana in the district of Puri. Stuff. It has been stated by Mr.
Patnaik.
Mr. Sambit Patnaik, Land Council, that the proposed road is going to be constructed on the land classified as Gochar, and due procedure for reserve the Gochar land for any other public purpose has not been followed. In this regard, a representation has been filed
To the Tahsildar Gopo.
To the Tahsildar Gopo, annexure 4 to the writ petition by urging him to stop the said construction over the Gochar land. But no action has been taken on the said representation as stated by Mr. Patnaik, Land Counsel for the petitioner. Having due regard to the nature of the concern as raised in this public interest litigation, we are of the view that it will be appropriate. Now, this writ petition can be disposed of with a direction on the opposite party number 3, the Tahsildar Gopo, to make an allegation is raised in the representation annexure 4 to this petition, and thereafter to ask the government, ask the administration, if required, to to follow the due procedure, if not followed, for purpose of utilizing the gochor class of land. Stop. But the primary duty of the Tahsildar would be to protect the gochor land, not to go for the reservation rampantly. Stop. Accordingly, this writ petition is stop. The Tahsildar shall pass the reasoned order on the representation of the petitioners within a period of 2 months from the date when the copy of this order be furnished to the Tahsildar Puri. Tahsildar Go. Okay.
Till disposal, my lord, the land may be protected, my lord.
I have read this. Till disposal, nothing would happen.
Nothing. My lord, the free copy of the order may.
A free copy of this order is supplied to Mr. Additional Government Advocate appearing for the state of those parties. Yes.
Item 13. My lord. Your pleasure. The cremation house was made over the gochor land, my lord.
Same allegation almost.
What is the purpose they are diverting the gochor land?
Gochor, that is in the village, gochor,
how they are occupying the gochor land? For purpose of any construction?
Construction of
Cremation ground.
Cremation ground. In this village, 4 plots are there, my lord. The cremation ground. Annexed 2 series, my lord.
The same Tahsildar Go also. Same order can be passed.
Annexed 2, the 3 floors, my lord. Para 5 of my petition, my lord.
Proposed party, this cremation ground, no?
The representation is at page 18.
Annexure 3.
Annexure 3, page 18. That same Tahsildar Go.
The collector is.
No. Tahsildar.
Tahsildar will take the pass.
Tahsildar will take care of.
All right, it's a similar order. This change in number. This. Within 2 months, free copy will be granted. Yes. All right. Next.
Item 14.
Listing, all these things that comes within his power. So now, the secretary, food and civil supplies, in instructing do this thing, that thing, all this. This is totally against the law. This matter, in fact, had come up before my Lord Justice. Suddenly that bench, the matter was hard at length, and my Lord, the assignment was doubtful. That is why it has been placed before lordship. And so far, the assignment under the Consumer Act is concerned. That is before my Lord Justice Panigrahi. But that is so far the matter is, any matter is passed under the Consumer Act. But this is totally functioning of a judiciary, quasi-judicial forum. So it may be either before your lordship, whatever your lordship think it proper.
Let us see. You just give the case number.
I'm just giving the case number.
Okay.
One second.
No, I'm just giving that case number. 26, application number 26270 of 2020.
Check up the record.
26270 of 2020.
This item 35 of today's list. A similar matter, in fact, your lordship have posted to 22nd, that Ratna Bhandar matter. So it would be better, only some wastage of 22nd of September along with the other matter and give the number.
You send one of your deputy to point out when the matter will be called out. Because we have to pass it.
That's correct. Another matter, I pray for an accommodation. I have some personal difficulty.
Just through your...
My associate.
Yes.
Because I know that your lordship is usually... I also don't want, but I have some genuine difficulty after that.
So Tripathi is here.
Okay. I'm deeply obliged. Once again, we are very happy to see your lordship here and wish that the period would have been much.
Thank you.
So, congratulations once again.
Personal appearance. Oh, is. What about the personal appearance?
Your lordship directed
Yes, item 17 now.
So constitution item should have been placed before a special bench loss. It was the order passed by lordship on 10th August 2023.
What is the difficulty in that?
10/8/2023. That should come up for the now Chief Justice sitting with Justice G. Satpathy.
What kind of order that was passed on 23/6?
That was some immediate for us he was while deliberating over the matter was in course of hearing. The Honorable the Supreme Court has directed for a proceeding before the State Bar Council. That only person he wants to modify, my friend wants to modify to recall that person. It was listed for hearing.
Then what is the operative part of the order? You want certain remarks has been made against you to be removed from that order. This is untrue. That is what. No, that is, he said that he is not contact and he doesn't want me to appear like but later on in handwritten letter was discovered from the record where the appearance stated that.
wait list, admittedly. And they're giving promotion till 2012, they're giving promotion out of that. Even after expiry of 3 years also, they are giving promotion to 107 and thereafter to 18%. There is no denial also. Now you also kindly come to the operative portion which affect us. Otherwise, the judgment, we have nothing to say here. Paragraph 11. I'm just reading paragraph, internal page 12, running page 57, last paragraph. We have also taken into consideration. Now I'm reading the whole paragraph because we have to go through the order passed by the tribunal. Have found that tribunal is giving no finding with respect to the legality and propriety of the instruction dated 13/8/2007. According to us, and in view of the admitted position, that there is no recruitment rule governing the field. Hence, in absence of statutory rule, the authority has got power to formulate the guideline by virtue of the executive instruction. The same has been done by the competent authority of the Fire Service of the State of Orissa by issuing letter dated 13/8/2007, providing the provision and process of selection as Assistant Station Officer. Now, as showing your receipt, Section 12 of the Orissa Police Act says, any instruction which will be issued by the IG of Police that must be subject to the approval of the state government. And only press people also show that. So this, so far as the IG's letter, 13/8/2007, admittedly it has not got the approval of the state government. Rather, IG of Police has clarified subsequently, we can give appointment because QNR doesn't say so. The next para. We have also taken into consideration the legality and propriety of the promotion having been granted, taking into consideration clause 5 of the letter dated 13/8/2007. The selection process since been initiated in the year 2007. The validity of the selectees prepared on the basis of the said selection process would be valid for 3 years. That is up to the year 2010. We are making an observation on the basis of the fact that the validity of condition number 5 of the letter dated 13/8/2007 has not been questioned. However, we have already expressed our view that even the selectees cannot be said to be valid for a period of 3 years or till the framing of the cadre rule, whichever is earlier. But since the government has given effect to the letter dated 13/8/2007 and the employees have already granted promotion in pursuance of the same, hence we are not expressing our views regarding the promotion already granted. But the next slide, within a period of 2 years, as has been decided under condition number 5. If it has been yet there, hence we are not expressing our view regarding the promotion already granted. We have nothing to say. But the next sentence, the was within the period of 2 years, as has been decided in condition number 5, that itself affecting the rights of the petitioners, we are not attached to that writ application. If you also look to the next page, Justice 12.2. Madam Justice Arthur was pointing out, and you also pointed out that the state government does not any promotion from the selectees prepared on the list of the selection conducted in 2007 for the region state government. That has nothing to do. So far we are concerned, yes, we have already got permission much prior to this. So now the only question is, if you also will see, kindly look to the PNR, sir. The PNR is very clear. That book also is available to full access. That 660 at page 342 of your access book. What will I tell 660. Appointment of assistant sub-inspectors. I let's get it. 660 as page 342 of your access book. Page 342. Yes. Top pillar 660A, 668, which deals with the promotion of to the post of assistant sub-inspector. Assistant sub-inspector will be appointed ordinarily in the following manner. 1. Matriculate constables who have passed the constable course of training and have had at least 7 years of service after the period spent on the training, and having been selected as per the procedure laid down in clause C of this rule, will be allowed to officiate as ASI and will also eligible for deputation to the ASI course of training for a period of 4 months, comprising of 1 month institutional basic training at designated training institution and 3 months practical training in the police station and shall be required to pass the final examination to be conducted simultaneously. Then 2, non-active also skip over. Then also important for our purpose. Twice a year, all the superintendent of police or the head of the states shall report to the IG of police the number of vacancy in the rank of ASI in the district public establishment reduced by the number of ASI course past constables as on 15th April and October of that year to take up the training in the ASI course. C. The selection of both matric and non-matric constable eligible under the condition laid down in clause 1 and 2 of subrule A will be made by means of a written test, which will ordinarily consist of law and rules and ability to write essay in English. The marks for each subject and the time to be allowed for each will be prescribed by the IG of police. The examination will be held centrally, or skip over, then kindly come to E. The constables after being selected by the selection board and allowed to officiate as ASI police pending passing the final training examination will not be entrusted with duty to conduct an inquiry or investigation as per the provision of the CRPC. The selected candidates shall be sent to designated training institutions for the institutional basic course of ASI training as prescribed by the DG and IG police from time to time. This we have completed. The certificate of physical fitness of each of the nominees to undergo the course of training is to be obtained from CDMO and be substituted with the nomination role before promotion to rank of ASIs. 2. On successful completion of the training, the candidate will place the state list to maintain at the state police headquarters. On the basis of the result of the final examination, the seniority internship will be determined according to the marks obtained by them in the final examination. In case if no candidate secure equal mark, no media is according to the relative seniority in the grades. The seniority rank of ASI shall be reckoned from the date of passing the final examination in ASI course of training. The candidate failed in the examination or skip over. And we all these 34 candidates, they have passed the training, they have completed the training course, and at this juncture, this judgment has come. Now, if you also look to the next page, except with the permission of the IG police or skip over, G, assistant sub-inspector promoted to rank shall be on probation for a period of 1 year. And there is a case law that has been referred to. You can also see that my uncle is showing that is the law. As far as power of the inspector last line, power of the inspector general of police to make rules has with the condition that it can be exercised subject to the approval of the state government. That section 12 also look again, so far the Orissa Police Act is concerned, on the basis of which this has been framed, this PMR rule has been framed. So we come to page 595 of your office book. 595. Section 12. Power of Inspector General to make rules. The Inspector General of Police may, let's get it, I think. Page 595 of that book. Orissa, the Police Act. Police Act 1861. Yes, sir. Yes, sir. Section 12. That is at page 595. Power of the power of Inspector General to make rules. The Inspector General of Police may from time to time, subject to the approval of the state government, frame such order and rules as he deems seems expedient relative to the organization, classification and distribution of work, distribution of the police force, the places in which the members of force shall reside, and the particular service to be performed by them, their inspection, description of arms, so and so, so and so, so and so. So it is subject to the approval of the state government. If you actually look to that, which the division bench has referred to, without considering the PMR, that is at page 20. Page 20, annexure 1 of the bill. Referring to zero. WPC 1 first case.
It is not, I believe this is not a decision of the division bench.
So it's a division and decision bench.
Not a judgment, only the issued by the IG police. That is 30 2007. Running test 20 at annexure 1. WPC 19875 of 2019. I think I was reading that brief. The first matter, first matter, yes. So look to that. This has been given emphasis and much forced by the division bench. So look to the last line.
Yes.
The result of the pre-promotional test course has remained valid for a period of 3 years or till the remaining of the cadre by the government, whichever is earlier. In fact, this instruction issued by the IG of police and considering the PMR, a single judge of this Honorable Court, where I was also incidentally counsel, it has been held, which has been appointed by the this is the judgment, right? And giving to us in view of that is also in case of the promotion case of ASI. In view of the fact and law as discussed above, this court is of the considered view that the validity of the select list published on 14/12/2020 as modified on 22/12/2020 shall continue for a period of 1 year or till the same is exhausted. But why say that it is exhausted? And this judgment has been upheld by the division bench. Both the judgment I can supply to Lordship, certified copy. Why I am saying so, brother?
No, till 1 year or till it is exhausted. That was full stop or whichever is earlier.
Which is not latter. That is there. Para 20. The operative person judgment. Well, that was a case of promotion, but that was another select list. That has nothing to do with this select list. Yeah, no, that is only considering the PMRs of this para 20 hours. So can you come to the concluding paragraph 20. Of course, the whole thing assigned, but the judgment has been upheld. Their only question was this is because 1 year that has been interpreted in saying that except movement there is no other rule. Because that was the select list for giving appointment to the ASI. And here is a case where the select list was prepared in 2007. Thereafter, no select list has been prepared till date. And every year, as I placed before Lordship under the PMR, every year twice they have to notify the vacancy position. And out of that select list, it has to be given promotion. And that was the case throughout by the state. So I, so far as that judgment, that is context altogether, but this is so far as that PMR is concerned, that has been taken note of by the Honorable Court and it has been upheld. But my entire argument for RCP is, if a select list, now I can conclude this, if a select list was prepared in 2007 and a mandate as per the PMR rules, it is a mandate on the part of the authority to report the vacancy position every year twice, and the vacancy position are being filled up even after expiry 3 years, and 107 plus 118 candidates have been admitted given appointment, and they actually doesn't agree.
But there is no any specific rule in this regard. No specific rule.
No specific rule. So silence about that. But
no, in this, if the rule is not providing any express provision, sometimes it happens there is a
sometimes also to the judgment of the Supreme Court. In all those cases, the select list has been prepared for giving appointment. Taking into consideration that case, it has been said that it should be 1 year because there's no up. But here is the case of promotion. They prepared the list and they prepared the list for the purpose of promotion, and out of that the list they have sent for training, that's statutory training, and that training they have undergone. And some people have got promotion and working as a resource. That's 107 and 18. We stand on the same footing as 107 and 18. Now, you can also say whether the judgment is also like to last time asked that whether that judgment will apply to them. Yes, that will also apply. That for state, it is for the state to say. If 107 will be governed by that judge, will continue the ASI, and the persons like us, the 34 candidates who have already passed the training course and they have been selected, they have appeared the 2 tests, they have been selected, thereafter they have undergone the training course and completed it. And at this juncture, why will we be treated differently? So only the line, if my division bench, that 3 years, within the 3 years, if that will be clarified, then I think the entire judgment will not happen.
That is the case.
That's it.
All right.
So far the judgment, I need not cite to you also, I've given a copy of the judgment. One judgment is reviewed. So far the person who are likely to be affected, who are affected even after the selection, if they are not being made parties, that judgment will be ignored, so far they are concerned. And the second judgment, they have a local standard to file independent writ applications to recall that judgment. And those judgments are only given to lordship. And even if it has been upheld by the Supreme Court in SLP, one person had filed a SLP or dismissed at the stage of admission. So you will also know that judgment are given directly at the point that SLP dismissal within the regions also. Here no reason I do say that cannot be barred for exercise power of review. That is the judgment I have given. I did not adjust your time because the judgment are.
Mr. Rautri, that SLP is converted to appeal.
Yes, then in that case it will be. You cannot get that in binding. Merger principle. Yes. Merger principle. That will be clarified. One paragraph I'm reading. That one paragraph.
You give just the paragraph number.
Yes, I'll give the number. Citation, I'll give the para numbers. Yes.
May I please? Well, here the first and foremost question is whether the present petitioners in this writ petition as well as in all other writ petitions, whether they stand on the similar footing who were the petitioners in the SLP. Now, my lord, may kindly see the cause title of the first writ petition. Page 4. Yes, ma'am.
You're referring to the writ petition?
Yes, ma'am. WPC 19875. Page 4. Serial number 11 is Prashant Kumar Nanda. Serial number 12, Subhendra Kumar Swain. Serial number 13, Kamala Kanta Puhana. Now, my lord, will kindly see my petitioner's name. Venudhara Behera, Amya Kumar Bhuya, Subhas Kumar Patra, and Dilip Kumar Nanda. Now, my lord, may kindly turn to page 39, annexure 8. Yes. Now, my lord, you can see page 39, annexure 8. This is the list wherein 34 persons were selected to undergo training. Page 39. This is office order number 18, dated 1/2/2016. Yes. In pursuance of Home Department letter number so-and-so dated 5/11/2015 containing directions to implement orders of Honorable OAT Cuttack Bench Cuttack dated 24/6/2015 passed in OA number so-and-so for promotion to the rank of Assistant Station Officer in Odisha Fire Service out of the selected drawn in the year 2007 till its exhaustion. As such, a CSB was convened on 19/1/2016 to assess the suitability of candidates out of existing panel in gradation list drawn during the pre-promotional test held on 23/9/2007 in order to fill up 34 numbers of vacancy in the rank of Assistant Station Officer by way of departmental promotion. The CSB scrutinized the nomination rolls along with service particulars of the eligible candidates and selected the following candidates for promotion to the rank of Assistant Station Officer in their respective category as mentioned against each. Now, my lord, we can see serial number 1. Havildar Santosh Kumar Gaura, Well, that he is the petitioner in WPC 31139 of 2021. Well, that is in the list. Third item. The next is Omniya Kumar Bhunya. That is the petitioner number 2 in the present writ petition 19875.
Yes.
Then serial number 3, Srikant Kumar Jena. Well, he is the petitioner in the second matter. Then Prafulla Kumar Parida, he is the petitioner in WPC 32544 of 2011. That is in the list also. Then serial 5, Satish Chandra Behera 32598 of 21. There he is the petitioner. Then serial number 6, Malaya Kumar Pradhan, he is the petitioner in 33622 of 2021. Then serial number 7, Dilip Kumar Nanda. He is the petitioner number 4 in the first.
All the names of the petitioners are here.
All the petitioners, including the pro forma opposite party numbers 11, 12, and 13. You can say these pro forma opposite parties 11 to 13, their names appear at serial 8, 9, and 10.
Yes.
Then another name, my lord, may kindly mark serial number 17.
He is not the petitioner. 17.
17 was the petitioner in another.
Alok Kumar Dev Goswami.
Yes, he was the petitioner in another writ petition with the same prayer as has been made in the first writ petition. That writ petition has been dismissed by this honorable court, and that order I have enclosed in along with my counter. Straight away, my lord, may kindly turn to annexure D by C by 3 of my counter.
Yes.
Counter affidavit filed by the opposite part numbers 1 to 5. Annexure C by 3, internal page 48. May I place my question? This is a wholly concept.
No, this running page number 48.
Yes, annexure C by 3 of my counter.
Okay.
Internal page of my counter of OP number 1 to 5.
Annexure A by 3.
Yes. Annexure C by 3.
Annexure C by 3.
Yes, ma'am.
Okay. Annexure C by 3 is an order of this court.
Yes, yes. That is the order passed by this honorable court at the instance of the person whose name is appearing at serial number 17. Alok Kumar Dev Goswami. You will see page 48, top is the name Alok Kumar Dev Goswami. This is a wholly misconceived writ petition where the prayer is for recall of an order passed by a division bench of this court more than 4 years ago in another writ petition to which the petitioner is not a party. Despite repeatedly telling the Land Counsel for the petitioner that such a course is not available in law, he is not prepared to relent. He then says that he should be permitted to amend the writ petition by changing the prayer clause. Merely changing the prayer clause will not help the petitioner in any way. Leaving it open to the petitioner to seek other appropriate remedies as may be available to him in accordance with law, the writ petition is dismissed.
Okay. That is your pointing out that his petition on the summons was dismissed.
Yes, it has been dismissed. And the same order is also under challenge here, passed by the other division.
This another writ petition?
Yes.
Readable, sorry.
Prayer is same.
No. Same order means the order which they were wanting to recall, they are again saying that that order will not apply to them.
Yes.
How can they they cannot challenge the order in this writ petition?
No, this is writ petition, they have challenged this order.
In the first writ petition, they have challenged the order passed in the 2017.
The prayer.
Yes.
Now, my lord, we can see annexure A, which is the order impugned in the writ petition. There, my lord, we can see it starts from page 44, annexure 10 of the writ petition.
Yes.
This was filed by Abhay Kumar Swami The next page you will also get page 45. 45 bottom, serial 7, 8 and 9.
What page is that?
Well, these are the pro forma of party number 11, 12 and 13. And these three names also appear at Annexure 8, serial number 8, 9 and 10.
Yes.
Well, these three persons challenging the self-same order, self-same common judgment at 6/7/2017 approached the Honorable Apex Court. That has been dismissed on merit.
Should you refer to the which page?
Page 45.
45 of your counter?
No, not the repeats.
Or that
Order which has been improved.
13566?
Yes.
Okay.
Page 45, bottom serial number 7, 8 and 9. These three opposite parties are now the pro forma opposite part numbers 11, 12 and 13.
There were interveners there or what? How is this name added in a peculiar manner? There were interveners.
It has been written as opposite party 7, 8, 9.
Impleted
by the order dated
by
15.
also
Yes.
interveners. Okay.
And these three persons stand on similar footing like that of the present petitioner and sent to training along with the present petitioners right on 1/2/2016 under Annexure 8.
Why are you relying on the observation of their judgment when it is under challenge in a separate writ appeal?
No, that is why, because I am challenging the maintainability of the writ petition itself. That is why I am drawing all these.
How the petition is not maintainable?
Yes.
Come straight to that point.
Yes, I am placing some judgment. Prior to placing this judgment, may I place the order of the Honorable Supreme Court that has been filed along with the counter affidavit filed in the connected case WPC 30991 of 2021.
Yes.
Prior to placing these judgments, may I invite my lord's attention to the order which has been passed by the Honorable Apex Court. And that is available at Annexure C/4 of State Counter in WPC 30991. I have also prepared a note. There I have also enclosed. That will be convenient for me. Last page, my lord, you can see. Top petition for special leave to appeal C number 25so arising out of impugned final judgment and order dated 6/7/2017 in WPC number 13566 of 2015 passed by the High Court of Orissa at Cuttack. And this is order dated 10/10/2017. Upon hearing the counsel for the court made the following order. We do not see any merit in this special leave petition, which is accordingly dismissed. After order of dismissal is filed on counsel for the petitioner seeks liberty to withdraw the special leave petition and pursue the matter with the authority concerned, which course is not permissible. So the leave was also refused. Now, my lord, may kindly turn to my judgments which I have placed.
Why have you just referred this SLP order? Well, for purpose of finality?
Yes.
But this is because this judgment is basically based on this any res judicata. If you want to say that it is already decided finally, there is certain exceptions also carved out when it doesn't become res judicata, when someone is not a party based on the principle of res judicata. Try to understand the basic principle of.
No, not res judicata. My contention is once the order is confirmed
That has to be res judicata, otherwise that will not operate against them. Suppose the issue is settled by this court. Wrongly or rightly, they are not the party.
No, that is why I placed all those documents that the present petitioners were similarly placed like that of the petitioners who were the opposite parties.
That's true, Mr. Muduri. Some persons are similarly placed exactly of the same color of the skin.
Yes.
Will not save his right to be continued in the litigation because he has to be there. Because we can also visualize a situation, someone appearing before us and presenting a different set of reasonings. The right actually flow from that I was not personally hurt. Maybe that would not have changed the course of the judgment.
In that event, what will happen? Well, suppose tomorrow these 15 persons have come. After passing of the order, now another person will from this list will come.
That is the reason why this Food Corporation of India case is referred several times by the Supreme Court. If there is a long number of cases, only because this is the Order 1 Rule 8, publish the notification in the newspaper so that the persons who are interested, they should come in such cases where so many persons interested are involved. That is the reason. If there is a public notice under Order 1 Rule 8, and this become, even in the case of the respondents also that is applicable. That is why the Food Corporation of India case of 1998. But in absence, someone may claim that I was not given the opportunity of hearing. That is exactly Mr. Raut says, exactly not in that circumstances of fact, but he has raised that issue that my right is still there. I can go there. There is some problem, but we'll ask the question, can we complete this? You cannot apply the principle of res judicata that way. Because if you go through the section 11, the first thing they said between the same parties.
No,
what has been chosen?
Yes.
Because of this, because without affording any opportunity to some other person, you cannot decide his right. This may appear to someone it is very mechanical, no substantive purpose is served, but this is the caution principle. We do not know how he is project his own case or whether there is any difference in the case. All these factors are there. Already we have taken note of this decision that in one matter they went to the Supreme Court, but the Supreme Court dismissed the appeal.
Yes. Now,
so the single judge's judgment has become final.
Yes, division bench judgment.
Division bench, the same way division bench also affirmed the single bench judgment.
No, because at that point of time, tribunal order was challenged before a division bench.
At that point of time, there was no single bench matter. So it is straight from the tribunal.
Yes. Okay. First judgment I will place, that is 1996 3 SEC 463.
Just give this again.
1996 3 SEC 463. I have given the blue color flag.
Oh, yes.
There were relevant paragraphs are paragraphs 3 to 5. May I place, madam?
Yes.
It is contended for the respondent that the dismissal of the SLP does not preclude the tribunal from reviewing the order since the dismissal was a non-speaking order. We fail to appreciate the contention of the respondent. In paragraph 4. But in this case, when the self-same main order was confirmed by this court, the question arises whether the tribunal has had power under Order 47 Rule 1 CPC or any other appropriate provision under the Tribunals Act to review the orders passed by it and confirmed by this court by refusing to grant leave. We find that the exercise of the review power is deleterious to the judicial discipline. Once this court has confirmed the order passed by the tribunal, that becomes final. Therefore, the tribunal cannot have any power to review the previous order which stands mod with the order passed by this court. It is next contended by the Land Council for the respondent that though the tribunal has communicated with the order of this court dated 25/8/1995, it has thereafter passed the order. It would mean that though it had the knowledge of dismissal of the order passed by this court, the tribunal has exercised the power of review and that therefore it cannot be said to be illegal. We are wholly unable to appreciate the contention of the Land Council. We could appreciate that if the tribunal had no knowledge of dismissal of the SLP, it might, in certain circumstances, review its order if it was found that the order was vitiated by any manifest error of law apparent on the face of the record. But having received the communication that this court has already upheld its order, the tribunal's exercise of power can be said to be audacious and without any judicial discipline. Under those circumstances, we do not think that the tribunal is justified in reviewing its own order when this court had confirmed the order passed earlier. Now, my lord, the next judgment. Flag 2, 1998, 7 SCC 386, yellow color flag.
Yes.
Their relevant paragraphs are paragraph 2 and 4. The rent controller ordered eviction of the appellants in an eviction petition filed by respondents 1 and 2 on the ground of willful default in payment of rent and bona fide requirement of the premises by respondents 1 and 2 for their own business. On appeal filed by the appellant tenants, it was found that there was a bona fide dispute with regard to the title of the property, which could be decided by the civil court. The appellate authority set aside the order of rent controller on 27/8/1983. Respondents 1 and 2 thereupon preferred revision petitions in the High Court, and by its order dated 7/1/1987, the High Court rejected both the revision petitions, conferring the view of the appellate authority. Agreed by the orders of the High Court dated 7/1/1987, respondents 1 and 2 filed SLPs C number 4039-4044 of 1987. The appellants appeared on caveat in the Supreme Court. Both the sides were represented by senior advocates of this court. After hearing Land Council for the parties, the special petitions were dismissed on 16/9/1987. After the dismissal of the special petitions by this court, the respondents filed review petitions CMPs 44 and 45 of 1994 in the High Court, seeking review of the order dismissing civil division petitions number so-and-so on 7/1/1987. It was the order dated 7/1/1987 which was the subject matter of challenge in SLP number so-and-so of 1987. There was also a delay of 2 to 1 days in filing the review petition in the High Court after the dismissal of the special petition. The Lord single judge by the order impugned for us not only condoned the delay of 221 days, but also reviewed the earlier orders made on 7/1/1987, reversed the orders made in civil division petitions, and allowed civil division petitions and ordered eviction of the tenant appellants. Aggrieved the appellants are before us against the order dated 7/4/1994 made in the review petition. Paragraph 4. The manner in which the Lord single judge of the High Court exercised the review jurisdiction after the special petitions against the self-same order had been dismissed by this court after hearing Land Council for the parties to say the least was not proper. Interference by the Land single judge at that stage is subversive of judicial discipline. The High Court was aware that the SLPs against the order dated 7/1/1987 had already been dismissed by this court. The High Court therefore had no power or jurisdiction to review the self-same order, which was the subject matter of challenge in the SLPs in this court after the challenge had failed. By passing the impugned order on 7/4/1994, judicial propriety has been sacrificed. After the dismissal of the special petition by this court on contest, no review petitions could be entertained by the High Court against the same order. The very entertainment of the review petitions in the facts and circumstances of the case was an affront to the order of this court. We express our strong disapproval and hope there would be no occasion in the future when we may have to say so. The jurisdiction exercised by the High Court under the circumstances was palpably erroneous. The respondents who approached the High Court after the dismissal of the SLPs by this court abused the process of the court and indulged in vexatious litigation. We strongly deprecate the matter in which the review petitions were filed and heard in the High Court after the dismissal of the SLPs by this court. The appeal deserved to be succeed on that short ground. The next, after this 1998 judgment of in Kunia Ahmad came in 2000. Relying upon Kunia Ahmad and this 1998, this judgment at flag 3.
Mr. Bhavili, there's some sort of factual difference.
Yes.
And you know the little bit of difference in the fact made a lot of difference in understanding the context of the case. Here that you have recent this the review of the order, which in the challenge before the SLP, and the SLP was dismissed, and that order sought to be reviewed. Number one, this is a particular fact. And another thing is that the
same party was pursued.
That is what there is a little distinction.
Here, that is why I placed first of all, I placed annexure 8. That is why.
That is I had said.
All these petitioners stand on similar footing like that of the petitioner who were before the Honorable Apex Court.
That is the problem. That is the problem. Actually, they are taking you from your point of view. That may be their advantage they are taking, because that is why they avoid all these things. Certain legal approach is there. Legal process has been provided in the statutes also. How to overcome these things. You are right. That if they are we can extend the reasoning by that way. If the
persons can intervene,
also intervener or anyway the parties in that proceeding, their fates are sealed, but they are not. There no notice was issued from the court.
Well, apart from
that is the distinguishing factor.
Apart from issue of notice, well, since out of the same panel, 3% intervened. So
that is the Food Corporation of India is so important. Food Corporation of India says in a panel there may be 1,000 persons. It is not possible in a judicial proceeding.
In a representative capacity, 1 or 3 persons outside the panel.
This is what I was waiting. They should come from you, the representative capacity.
No, that is why, well, out of these 34, these 3% represented all these 34 persons.
You are saying represented, but for purpose of representation, a particular procedure has to be followed. And the newspaper publication is a mandatory one. You come to Order 1 Rule 8A of the CPC. In principle, we adopt also in the writ petition. There should be a public notification that such people as far as they are, and the application usually should come from these representatives. We say that we want to represent all of them. Then only these persons become their representative, otherwise not. This is number one. But the FCI has an innovative approach they have taken. Even the petitioner, right? Petitioner may be the government. Government thinks, suppose in an appeal, the writ petition was by the aggrieved persons and they are lot in number. They filed, but later on, some way of the intervention, they were not made party. You have your responsibility to inform all the person. Then also the FCI says you go through the method of the representation. There is Order 1 Rule 8. You publish a newspaper and 3-4 persons you serve the usual notice. That will serve the purpose. But by implication, you cannot say someone's legal right unless you are authorized. You do not have any right to represent.
And here the distinguishing feature is all these persons, including the
because there is one judgment I'm telling you. While this dilating the principles of Order 3 Rule 3, that in CPC the authorized isn't. The same principle, Justice Pal has dilated the matter to the extent unless except that someone is related, suppose an husband and wife. This kind of bonding, that they must know each other. Even in case of an Order 3 Rule 3 also, there should be some written authorization. Otherwise, the court should not entertain them. Because there's a lot of chances of the mischief. Law-averse mischief. That is why these protections are given to the person. We have understood your point. You are absolutely right. Actually, usually you can assume that they knew it about the litigation. They remain the bystanders.
Yes.
And the bystanders doesn't have any right.
And you will see from my list of dates that has been supplied along with the written. Well, after dismissal of the SLP, one of these petition has been filed.
Only on that ground we are not party. And so
Well, they were watching. They were watching what is happening where.
no, this is no, they are watching, but there is no document that they were aware of these things. Then in 1987 Supreme Court decision, A.K. Kapoor versus Union of India. Right. Those who are waiting for the opportunity, they should not be given any opportunity in future. So this all.
Next judgment, my lord. That orange color flag in 2001.
Rajamouli.
Yes, Rajamouli. Well, in this judgment, this 98 judgment,
Yes.
also Kuniyama 2000 Supreme Court, that has also been taken. After considering both the side judgments, relevant portion, my lord, is para 4. But page 4.1. May I please? Following the decision in the case of Kuniyama.
This part is the basically on the doctrine of merger.
Yes. Well, here also you will also can say second person.
Right.
Following the decision in the case of Kuniyama, we are of the view that the dismissal of the special petition against the main judgment of the High Court would not constitute res judicata when a special petition is filed against the order passed in the review petition, provided the review petition was filed prior to filing of the special petition against the main judgment of the High Court. The position would be different where after dismissal of the special petition against the main judgment, the party files a review petition after a long delay on the ground that the party was prosecuting remedy by a special petition. In such a situation, the filing of review would be an abuse of the process of law. We are in agreement with the view taken by Maligai Partnership Firm. And that if the High Court allows the review petition file was dismissed after condemnation, it would be treated as an approach. So after taking into consideration Kuniyama, a different view has been taken.
Right, there is there. Even Kunaya Ahmed also there is a different view. Because of the different situation.
Yes.
There says a dismissal of the SLP. There can be the right type of dismissal. Kunaya Ahmed itself is some dismissal, a 2-3 line order dismissal, no reasoning, nothing of that sort. And other SLP, after going through all the reasoning, Supreme Court, but that will the merger. The nature of consideration will determine whether it is a merger or not. The other decision here, Krishna Kumar, no.
So that is on a different context. Except first case, in all these cases, their claim is that we should be given appointment under the old rule, following PMR 660, and not according to the 2021 rules. That is the latest law that 1987 Supreme Court has been overruled. That is the pink color flag.
5.
Yes. 2023 3 SCC 773.
You are referring to paragraphs?
In 2019, volume 4 SCC 319, paragraphs 4 to 7. (2019) Supreme Court, I am placing reliance upon paragraph 4 to 7 and 10 to 14.
Yes.
Paragraph 4. Writ proceedings were instituted before the High Court with a given that the promotion of the post of Havildar was to a lower and inferior rank of warrant officer, whereas the promotion ought to have been made to the rank of Naib Subedar. The High Court allowed the writ petition by holding that despite the changes which were brought about the structure of Assam Rifles in 2011, the rights which had accrued prior to the enforcement of the changed structure in favor of Havildars but being considered for promotion of Naib Subedars were required to be enforced. The High Court observed that it is now well settled that vacancies occurring prior to amendment or creation of the recruitment rules are to be governed by the rules which existed at the time of occurrence of the vacancy. On this basis, the High Court directed the appellant to consider the case of the respondents and other havaldars for promotion to the post of Naib Subhasis against vacancies which had occurred prior to changes which were carried out in 2011 and before the enforcement of the recruitment rules 2012. Assailing the judgment, the Union of India is in appeal. Now, my lord, paragraph 10. In considering the rival submissions, it must at the outset be noted that it is well settled that there is no vested right to promotion, but a right to be considered for promotion in accordance with the rules which prevail on the date.
You are reading from this Rajkumar.
Krishna Kumar.
Krishna Kumar. Sorry, I am just following the Rajkumar. Yes.
Krishna Kumar, 2019, volume 4 is
considering the rival submission.
Yes, paragraph 10. In considering the rival submission, it must at the outset be noted that it is well settled that there is no vested right to promotion, but a right be considered for promotion in accordance with the rules which prevail on the date on which consideration for promotion takes place. This court has held that there is no rule of universal application to the effect that vacancies must necessarily be filled in on the basis of the law which existed on the date when they arose. The decision of this court in Y.V. Rangaya versus J. Srinivas Rao has been construed in subsequent decisions as a case where the applicable rules require the process of promotion or selection to be completed within a stipulated time. Hence, it has been held in H.S. Grewal versus Union of India that the creation of an intermediate post would not amount to an interference with the vested right to promotion. Now, paragraph 11, Deepak Agrawal case judgment has been noted down. 12 also, Nikhil Ranjan Chakravarti. Then paragraph 13. In view of this statement of the law, it is evident that once the structure of Assam Rifles underwent a change following the creation of the intermediate post of warrant officer, persons holding the post of Havaldar would be considered for promotion to the post of warrant officer. The intermediate post of warrant officer was created as a result of the restructuring exercise. The High Court was, in our view, in error in postulating that vacancies which arose prior to amendment of the recruitment rules would necessarily be governed by the rules which existed at the time of occurrence of the vacancy. As the decided cases noted earlier indicate, there is no such rule of absolute or universal application. The entire basis of the decision of the High Court was that those who were recruited prior to the restructuring exercise and were holding the post of Havaldars had accrued a vested right of promotion to the post of Naib Subhadar. This does not reflect the correct position of law. The right is to be considered for promotion in accordance with the rules as they exist when the exercise is carried out for promotion.
That is the law. Before that, this when the words are being used, that is not absolutely rigid rule like that.
Yes.
That has to be there. That the previous in paragraph 12 you come.
Yes.
This is a case from Tripura, state of Tripura versus Nikhil Ranjan Chakravorty.
The law is thus clear. That
this come when the Nikhil Ranjan Chakravorty, Deepak Agarwal also fell for first critical analysis, and they are said in any case, just these last four.
Yes, in any case, since there was no accrued right, nor was there any mandate that vacancies must be filled invariably by the law existing on the date when the vacancy arose, the state was within its rights to stipulate that the vacancies be filled in accordance with the rules as amended. Secondly, the process to amend the rules had also begun well before the notification dated 24.
This is a similar proposition of law.
Yes.
But the phrasing is something different. It says one way there is no inflexible rule, means there is a further scope, because they also not say that cannot be done. There is a declaration of law. This is that cannot be. As a matter of right, you cannot. But if it is shown that two classes were created, one were accommodated, other was not, but they are selected in the same panel. Question comes, it is not the application of rule. Selection has been done to some extent under the old rule, and it is a continuous process. Whether the new rule can again make this entire panel a nullity and they will start the selection process again. This is a question of the discrimination would come.
There I will place.
No, if you say this is not a selection, I understand. But this is not the stand of the government. Government says this is selection. Panel, they have passed through all the test of selection. We kept it. Even in 2011, some people, 25 people were appointed from the panel. And your rule also doesn't say very clearly that is unless exhausted, but communication shows the idea was till it exhausts. So whether these judgments can apply in such circumstances.
There my reply will be, Your Lordship can see page 20, annexure 1 of the present writ petition. First writ petition.
That has been read out by just Mr. Rautri also.
Yes.
Just come again.
Yes.
That is a circular by letter 13/8/2007.
Yes, letter. And the subject is promotion to the rank of ASO in Odisha Fire Service. In order to fill up the existing and anticipated vacancy in the rank of ASO by the end of 2007, a pre-promotional test is to be held shortly.
You should come to the paragraph 5. That is what has been pointed out to us.
Yes. No. Why, my lord, they fixed all these things? That is reflected in the first paragraph. Because the draft rule was pending for approval. That is what I was placing.
Yes.
As the draft fire service manual as well as the draft OFS method of recruitment and condition service rules are yet to be approved by the government, the previous procedure followed for promotion to the rank of assistant station officer as prescribed under Rule 660A of the police manual is decided to be adopted for filling of the post of ASO in Odisha Fire Service. The criteria for promotion is as follows. Serial 5. The results of pre-promotional test boards shall remain valid for a period of 3 years or till the framing of the cadre rule by the government, whichever is earlier.
Yes.
Well, this clause has never been challenged by any of the petitioners.
Yes.
And in the meantime, new rule has come into force.
But when?
Accordingly, on the basis of new rule, we sought for the names to undergo pre-promotional post of training, but that has been stayed by this honorable court. As a result, we are not in a position to fill up this promotional post in accordance with the new rule.
When the new rules came into operation?
That I have reflected in my note.
2021.
Only one line minute.
25/8/2021.
Just you will get. Let him complete. He is almost completing.
25/8/2021. Serial number 25 of my list of dates.
21?
25/8. 2021.
All right.
And now, in view of the judgment of this honorable court, direction given by this honorable court, which has been upheld by the honorable court, well, we have to go for fresh selection after the new rule has come into force.
All right. All right. That's all. I guess. Yes, Mr. Rautri.
So one line. So what my friend said, that very letter, you also look to that letter again at page 20.
Yes, yes.
That letter starts with in order to fill up the existing and anticipated vacancies. And my friend said this has not been challenged. This particular clause has not been challenged. It also look to the judgment of the tribunal. In fact, tribunal has noted that. In fact, the person they will approve the tribunal, which has been implemented by giving us a permission, also look to that judgment. That is at
just again, since you are on legs that I was just pointing out, the result of the pre-promotional test shall remain valid for a period of 3 years.
Yes.
That also provided by the rules, or till the framing of the cadre rules by the government, whichever is earlier.
Yes.
Mr. Muduli says that this provision has not been challenged.
This has been challenged. You also look to that. That is also
what is state has been challenged.
My submission is none of the petitioners have challenged it. Hello. One way they are saying that in the tribunal we are not parties. Now they will rely upon this person of the tribunal judgment which is in their favor.
No, they cannot do that.
What the High Court also if you actually look to the judgment of the tribunal, which was reversed by the government, I think the prayer made in the original application also look to that. The very judgment also look to that.
No, it is not your prayer.
No, it was filed by some other persons. The prayer was that it should be 30% or 50%. That was the prayer.
They never raised.
Rather, it was a question that whether this executive instruction or letter, whether this will sustain in view of section 12. That was the question. That the tribunal answered that. Now, tribunal said PMR will even force. And PMR will be prescribed time limit. So that thing in the other case, Russia said it is exhausted. And one judgment, my grandfather argued, I said, look to that one judgment I given in 2019, where all these judgments have been taken into consideration, and this Pune Mohammed case has also been considered. That I am giving, that is citation I am giving, that is 2019 SCC page 376. I showed 2-3 paragraphs. 2009 SCC page 376. Koda Distilleries Limited versus
2009 or
2019.
4 SCC?
4 SCC, page 376. But I have given copy of the judgment of Manipatra that I have given to us. So look to paragraph 8 and paragraph 8, 9 and 28. Very short paragraph. Para 8, 9. Dita copy the Para 8. Let's get it.
Just a minute. Sorry. It is in your compilation, it is there.
Is there.
Okay.
2019. Patna Code Distilleries. Yes.
Yes.
Let's come to paragraph 8. Land Justice Dot. Right. As can be seen from the above order, the reason for dismissal of the review petition is that the Appeals Court has already dismissed the special petition against the High Court judgment dated 12th November 2008. Therefore, the review of the said judgment by the High Court is not permissible. It is this order in review petition which is challenged in this proceeding in as much as case of the appellant is that when the special petition was dismissed in meeting and not by speaking order, there are ways that to entertain the review petition by the High Court. A dismissal of the special in meeting by non-speaking order does not amount to merger of the High Court judgment with that of the Supreme Court. Para 9. The question of law which needs to be determined in the aforesaid circumstances is as to whether review petition is maintained before the High Court seeking review of a judgment against whom the special petition has already been dismissed by this court. Then kindly come to paragraph 28. Para 27 and 28. That is the conclusive paragraph 27 and 28. From a cumulative review of the various judgments, we sum up the legal position as under. The conclusion rendered by the three-judge bench of this court in Kudanabad and summed up in paragraph 34 and affirmed and reiterated. We reiterated the conclusion relevant for these cases as under Roman 4. An order of refusal special leave to appeal may be a non-speaking order or speaking one. In either case, it does not attract the doctrine of merger. An order refusing special leave to appeal does not stand substituted in place of the order under challenge. All that it means is that court was not inclined to exercise its discretion so as to allow the appeal being filed. In para 5. If the order refusing to leave to appeal is a speaking order, that is, give reasons for refusing to grant leave, then the order has two implications. Firstly, the statement of law contained in the order is a declaration of law by the Supreme Court within the meaning of Article 141 of the Constitution. Secondly, other than the declaration of law, whatever is stated in the order and the finding recorded by the Supreme Court, which will bind the parties thereto, and also the court, tribunal, or authority in any proceeding subsequent thereto by way of judicial discipline. The Supreme Court being the apex court of the country. But this does not amount to saying that the order of the court, tribunal, and authority below has been merged in the order of the Supreme Court, rejecting the special petition, or that the order of the Supreme Court is the only order binding or rejudicata in subsequent proceeding between the parties. and 6. Once a writ to appeal has been granted and appellate jurisdiction of Supreme Court has been invoked, the order passed in appeal would attract the doctrine of merger. The order may be reversal, modification, or mere affirmation. And 7. An appeal having been preferred on a petition seeking leave to appeal having been converted into appeal before the Supreme Court, the jurisdiction of the High Court to entertain a new petition is lost thereafter, as provided in Summary 1 of Rule 1, Order 47 of CPC. C. Once you hold that law laid down in CORAM order is to be followed, it will not make any difference whether the new petition was filed before filing of this special petition or was filed after the dismissal of the special petition. Such a situation is covered in paragraph 37 of CORAM order case, then paragraph 28. Applying the aforesaid principle, the outcome of this appeal would be as under. Civil appeal arising out of civil petition number so and so. In an instant case, since the leave petition was dismissed in limine without giving a reason, the review petition filed by the appellant in the High Court would be maintainable and should have been decided in May. Order dated 12th November 2008 passed by the High Court is accordingly set aside and the matter is remitted back to High Court for deciding review petition on merit. Civil appeal disposed of. When civil appeal arising out of special petition number so and so, in this case, we find that the special petition was dismissed to the following order. We find no way to interfere with the interim order. This is exactly the same thing here. The special petition is dismissed. Here also, special petition was dismissed in limine and without any speaking order. After the dismissal of the special petition, the respondent in this appeal had approached the High Court with a review petition. Said review petition is allowed by passing order dated 12th December 2012 on the ground of supersession of material facts by the appellant hearing and commission of fraud on the court. Such a review petition was maintainable. Therefore, High Court was empowered to entertain the same on merit in so far the appeal of the appellant challenging the order dated so and so on merit is concerned, the matter shall be placed before the regular board to decide the same. So this is and so far the non-joining party people also will look to that Khetravasi Vishwal's case. It's a case of Orissa High Court that I am giving. That is Khetravasi Vishwal versus Ajay Kumar Bara. One paragraph I will show you. That's it. Yeah. Yes. This has been again reconsidered by another judgment that you also kindly look at 2022. Yes, we'll look to that. That is Employee State Insurance Corporation of versus key-based cold storage. Okay. Could be. I want to give it. Yes. The Employee State Insurance Corporation, that is 2022 Supreme Court 2550. Right?
Year? 2000? Yeah.
2022 Supreme Court, SC 2550. Para 27 and 28. The Khetravasi Vishwas case are referred to also.
Para 27 and 28.
Yes.
Yes.
Para 27. The above judgment suggests that for non-Muslim party, the proceeding at the instance of the respondent would not be legally maintainable. Such a plea was specifically raised by the appellates before the High Court, but this was rejected with the observation that the issue of probability before the trial court the issue of probability before the trial court. In this context, it is necessary to keep in mind the Supreme Court judgment in Employee State Insurance was rendered on such and such that whereas the judgment in favor of the appellant was rendered by EI courts much earlier on 21/6/2006. Therefore, for the appellant, it could have been impossible to rely on the ratio in the subsequent judgment of the Supreme Court to argue on the non-maintainability of the respondent's proceeding for non-implement of concerned employees. Para 20. In any case, non-member of the necessary party goes to the root of the matter and could also be fatal to the legal proceeding. But this we can usually read in the of this court. Khetravasi Vishwal versus Ajay Kumar Bara versus 2004 1 SCC page 317. While it was held as follows, quotation: the procedural law as well as the substantive law both mandates that in absence of a necessary party, the order passed is a nullity and does not have a binding effect. This has been followed and I have given the other copy of the judgment. That's all, man.
All right.
May I assist your lordships? One line, the judgment which is sought to be reviewed, your lordships. In page 8, running page 53. The applicant, however, have challenged the letter dated 13/8/2007 to quash that part of the decision of the authority by which the qualifying mark has been fixed at 50%, but before the tribunal, they have not questioned the decision of authority regarding validity of the period of the list. And that cannot be reason, being that they are also wanted to be part and parcel of the said select list, for which they were also seeking direction from the tribunal to figure them in that select list on the basis of reducing the minimum qualifying mark of 50 to 30 in subject, and that being the reason stipulation made in the letter dated 13/8/2007 regarding validity of the select list has not been questioned by the petitioners, but very surprisingly, before this court, they have made a U-turn, and in course of argument, counsel representing the petitions has submitted that now they are challenging the period of validity. So that was not an issue really before the court. Therefore, court forgot about us that this band of persons are in the waiting list to be considered. A right has accrued in the present petitioners and others that they should get a chance of consideration. That aspect was because everyone was swayed by this word select list. It was a qualifying list. They are qualified to be considered. Those who are not qualified to be considered at all, they came and used that because of the word used repeatedly, that select list. Court was possibly persuaded in our absence. Had we been there, that's what I was pressing before your lordship. Had we been there, we would have explained the matter. This is not the final select list. So the band of persons were considered time to time. From out of the list, first 20 persons, then some persons, then 107 persons, then another set of persons, 18 persons, then some of us, 34 persons, they received the consideration. And some of us also there waiting to be considered. At this stage, this confusion, the select list word possibly misled everybody. That is what I beg to say, your lordships. And states stood with us in the previous round of litigation.
When you say this is not as a part of the select list,
this was a qualified list.
Qualified for consideration of selection.
Exactly. And some of us received consideration, some of us got appointment, some of us are still on the line to be considered selection. So 64%.
Just a minute. These are the consensus view of all the petitioners.
Yes.
What Mr. Mohanty is now projecting.
So for 30, I am appealing for those 34%. They are already considered, they have already been selected, they have already undergone the training.
And even qualified in the training also.
No, all these 34% are not here.
No, not may not be here. But I am appealing out of the 34%. I may not be petition for all 34.
Only 14 to 15% are here.
Maybe.
Don't worry, since it is not a repetition of we say that it will be confined to the petitions only.
One more thing, Your Lordship.
Any relief.
Yes. One more thing, Your Lordship. This is a responsible post. And now, in the meantime, the list was prepared in the year 2007.
You all understand the difficulty is all there.
Because in case of emergency, they have to respond.
We are still responsible. Presently, in absence of vacancy, all of us who are trained and not trained, everybody is discharging that duty in the high responsibility. The state during last education supported us, and now
no, this judgment is binding on me. I cannot take a different stand.
That is the responses of that.
The judgment is binding on me. Apex court order is also binding on me. That is why I framed the new rule.
I am an unsuccessful candidate. 9 and 10. But my notion is, if these things will allow, then we are suffering. This is for 3 years.
we have failed. But it doesn't mean after 3 years we have again we have and in the meantime so many persons are qualified for the got qualification. But director by worship the annexure one.
You are referring for which petition?
Annexure one.
Yes.
There is 516 whenever you lordship see the writ application annexure one. Page 30. Annexure 2, page annexure 1, page 20. Annexure 1. In order to fill up the existing and anticipated vacancy in the rank of ASO by the end of 2007, a pre-promotional test is to be held. So shortly, pause for a moment. This is a test for 2007 vacancy. Your lordship see my counter annexure B by 9. A by 9, sorry. Annexure A by 9. Lordship got it?
Yes.
One. That in order to fill up empty vacancies in the rank of assistant station officer, a written test is conducted in the year 2007 in accordance with provisions prescribed to 660 police manual. This is vacancy of 2007. And in a direction, you will also see annexure B by 9.
Yes.
At page same year. B by 9, page 19. Page 19. Page 15, madam. The impugned judgment which is in challenge 13566 of 2015 on the direction of on a report, a vacancy position, as well as year-wise vacancy position, as well as filling position is given. Now, it comes to page 16. Central Selection Board, SCB, was held and held 24/10/2007.
Page you are referring?
16. Page 16 of D9 intake account.
Page 16 of the writ petition.
No, madam. Counter of 9 and 10.
9 and 10, okay. You present only 9 and 10.
Yes, madam. 9 and 10.
Yes.
You will also see the page 16, 1. Central Selection Board, CSP was held and held for 20 posts in 24/10 to fill up the number of posts of ASO. Pause for it. In B, you will also see B. In the year 2007, 20 number of vacancy in the rank of assistant session officer arose indicated below. Where it is occurred, where given. Once it is 20, it is for the 2007 vacancy. Once the 2007 vacancy is built up, that is the post. That is the validity of selection list. Select is whatever you may say. That line of decisions. Where there is, where I have given the decisions also in my note.
Yes.
Well, this is Mukul, Saika and others was to process state of Assam and others.
That is relating to the
recruitment.
The principle is same, my lord. Vacancy, 1 year's vacancy cannot be filled up by other year.
This is not professional posted direct recruitment.
This is, that's as well. But principle is that, sir. Vacancy of a particular year cannot be filled up in other years. This is all future vacancy. How could you fill up the future vacancy? You know, what will be the fate of the other persons who are lining the promotion?
Yes.
Well, that is my, that's, I have given, that is 2009.
One is CC 386 already.
Yes, ma'am. 2009, 1 SCC 386. That's definitely a recruitment case. But principle is
only referring to the paragraph 44, I think.
Yes, madam.
All right.
Later. Your Lordship, see paragraph 33. Paragraph 33. At the outset, should be noticed that select list prepared by APSC could be used to fill up the notified vacancy. This notified vacancy is 20 here in our case, and no future vacancy. If the requisition and advertisement was only for 27 posts, the state cannot appoint more than number of posts advertised. Even though APSC had prepared a list of 64 candidates, the select list got adjusted, but all the 27 posts are filled up. Therefore, the candidates below the 27 appointed candidate have no right to claim appointment to any vacancy for which selection was not held. The fact that evidently and admittedly the names of the appellant appeared in the select list in 7725 below the persons who have been appointed on merit list against 27 vacancy, and as such there could not have appointed in excess of number of advertisements, as the currency of select list had expired. As soon as the number of posts advertised are filled up, therefore the appointment beyond the number of posts advertised would not fill up the vacancy being filled up. Direct candidates in violation of quota rules. This is a notification for 20 posts for 2000, end of 2000. If this vacancy is filled up, then what is the question?
Yes.
Or whatever they have appointed after 2020, they are all illegal. But however, they have appointed and so many years. That's why the government said it will be decided by the government.
All right.
This is same thing I repeated in another distance. Another two, same the same line. That is 2010 6 SEC.
This is a similar principle, just reproduce the principle.
The business principle, ballot.
Yes.
But in one case, 2006 SEC 777, what I see get the only. This is a Orissa case, it gone to Supreme Court. Select list cannot be treated as a perpetual reservoir for purpose of appointments. If selection process is over.
You are reading from which paragraph?
2010 6 SEC.
Which paragraph?
I am reading actually your Lordship classification A.
Recitum A. In which page?
That is 777. Second one, mate. Second judgment.
Okay.
Second judgment. Service law. Recruitment.
In the paragraph which you are reading, it is which paragraph?
Well, it is classitum A.
Classitum A, so every.
Yes, yes, I am so sure, Dr. Akagali. Just a minute, my friend. Just a minute. Hello, 17.
Okay.
In the instant case, it is required to be examined in view of aforesaid settled position. The 1985 rules provides for determining the number of vacancies and holding competitive examination ordinarily once a year. The select list is prepared so also the valid for 1 year. The instant case.
No, that will not apply in this case because the rule provides the 3 years. So that will not apply here. When the rules provide certain thing, it will be governed by rules only.
Rule provides.
It will not apply in this present case, but it is the general principle.
General principle. Just one. Little below, the authority has taken a decision to fill up 33 vacancies. Thus, a select list of 63% was prepared. It is also evident from record that some more appointments had been made over and above the 33 determined vacancies. Thus, once the selection process in respect of number of vacancies so determined came to an end, that it is no more open to offer appointment to persons. Well, that is the principle they have decided. That is earlier it is similar to earlier here in this one also.
Then we have to continue tomorrow because we have fixed one matter with little children.
I think it is closed.
No, Mr. Patnaik, I don't know.
Well, I takes about 10 minutes more.
No, not today is not possible.
Tomorrow?
Tomorrow. Mr. Roy?
My lords, I am waiting for my turn.
We are excellent matter again tomorrow because today, because two very young children.
Yes, yes. Actually, Lordship picked the matter at 2 p.m. But Lordship took up item 36. So
36 is a part-out matter. That is this gets.
I also manage a part-out matter.
Not only that day it is part-out.
It's all right, matters.
Matter also tomorrow. Huh?
Tomorrow at matters, if Lordship will be kind enough.
2 p.m. tomorrow.
At 2 p.m. Matters.
Now, matter also 2 p.m.
That will also.
Matters, then
that matter will be just.
My matter is not 5 minutes. More than 5 minutes.
Now, I'm aware about Mr. Pari that he will be confined within 5 minutes. I don't think he's also not today.
Yeah. Well, every time this is happening, it is up to your lordships. I have no.
No, we are fixing the matter. And Mr. Patnaik, tomorrow, please make your submission very precise. Because we got the entire issue, no? That you just point out this thing.
If it is inconvenient, then it will come to next date.
No. We'll complete it. It is rolling in the cosmos for a long time. My idea was that it would be complete today itself, but it has not been done.
It is no time in the matter.
My lord, item 30. Limitation point, notice to go.
It will come tomorrow.
And matter is 2 o'clock. This matter is 2 o'clock.
This matter will be 2 o'clock, but after Justice Roy's matter, Mr. Roy's matter. No, because most of the Roys are justices. Starting from the first Chief Justice.
Yes.
Lord, item number 18 is to come.
Is this manual here? No matter, just talk to the court master, he will give the date. But tomorrow, Mr. Patnaik, he has Please don't take more than 10 minutes.
Because state government has argued other point, yes, and I take 10 minutes.
I thought they used to support the submission of the state application. That's all.
Wait to your lordship, before I begin the matter, let me candidly say that the order, after I read the order, in fact, I thought no review application required to be filed. Now, my associate actually insisted should be filed because of the fact that the criminal case 498A that was initiated, that has ended in acquittal, and a divorce case was filed that has also been decreed. That was not brought to your lordship notice at the relevant time when the matter was taken up for hearing. But that was way back in 1991, 98, my lord. But in that case, after the divorce was done, the wife didn't contest. He got married again and they got 2 children. The children are minor, they're prosecuting their studies in school. If your lordship takes the entire fact into consideration, he'll be, I think, retired recently that I was told. I don't know the exact date of superannuation, but he will get about 40,000 rupees. The first wife is supported by 2 sons who are now in service. The second wife is there and 2 children are there. So what he begs to submit before lordship. Right. Your action is correct. But we have to file for the trial court. But they will not look into the matter because your lordships have already passed the order. If you actually observe, yes, that's right. Right. Your lordship is correct, my lord. If lordship makes an observation, that will give a chance him to apply.
The learned counsel who was appearing for the other side, can he be served or is he willing? At times they don't wish to appear, but then that will shorten the process.
I thought today. The name appears not actually.
Name doesn't appear today. Chanchala Behra.
Yes.
The name doesn't appear. In the cause list, it is not there.
If you want, I can serve a copy. I'll offer him a copy.
I mean, Mr. Panire can request.
Yes,
if he is willing, or else you have to take notice.
I think Mr. Kuntia,
JK Kuntia. Yes.
We pick the matter of 21st reading. Just request him, if it doesn't come, we issue the formal notice.
There are two appeals.
Yes.
So that's first appeal CRLA number 455 of 2008. In respect of husband, he has been convicted under section 498, 304B and 302 of IPC and array for life. So for the second CRLA is concerned, let's out of 4 appellants, chorus number 1, appellant number 1 is dead, and as against CRLA is abated, there is an order passed by this court. It is single judge matter. Second item is a single judge matter.
Why it is before us? Why it is before us? If it is a single judge matter?
Because these are the in-laws. First one is the husband, arising out of one JR case. Since my lord is hearing the first, the judgment is 1, that's why it has been tagged.
Okay, judgment is 1.
1. Okay. So that's why it has been tagged.
It's justified. Okay. So what is the submission in the first case?
So far as
I believe you are ready. Huh?
Yes, I am ready, but it will take time, Lord, because Ismail and Senior is appearing for the informant.
No, I am there, my lord. For informant, I am there. But state is there, sir.
He is ready, I think.
Yes, sir.
Should we start today or we are just asking for time? Because we will not stop it. Once we take up the matter, there will be no adjournment.
No, I can argue.
You just argue for half an hour today.
So far as first appeal is concerned, BMOD is concerned.
As you say, there is the common judgment in order.
Yes, ma'am.
Let us look at that way, that we are also hearing the second matter.
Yes. But here, this is a case, marriage was taken place 9/5/2005. But 2 dates are important. Marriage was solemnized on 9/5/2005. And death has occurred on 1/10/2005.
Within 7 years.
Yes, my lord. So within 7 years. Marriage date, but 9/5/2005 is the date of marriage.
And death took place on
1/10/2005.
Oh, 5 months. 1/10/2005.
Well,
5 months.
4 months.
Something or
yes, 4 months, 21 days, I think so. Yes, 4 months, 21 days, my lord.
Yes.
But this is a case where there is no direct evidence.
No, it's obvious.
Western circumstantial evidence.
That is obvious. That is obvious. We understand. But tell us, what is the general allegation made in the first information report against you? General allegation in the first information report.
Yes, that my lord, first information report on 1/10/2005. That my lord will find from the paperwork at page 70. Starts from 70.
And when that first information report filed, immediately after death?
Mala?
Immediately after death.
Yes. On the very same day, at 11:30 p.m. Although it was occurred in the morning, but FIR was lodged at 11:30 p.m.
All right, on the same day.
Right, on the very same day.
How this?
Well, there are 2 doctors, PW5 and PW19. So both are categorically stated. This is a normal death. The cause of death is cardiac arrest. Both the doctors have categorically said.
Both the doctors mean the postmortem doctor?
Yes, PW5 and PW19. Both have categorical stated in their evidence. This is a cardiac arrest and a normal death.
But what is the allegations on 1/10/2005 when this information was filed?
But so far as allegations is concerned, there was a dowry demand. And out of dowry demand, there was a torture, and out of torture, this was only including the husband, I killed her.
Okay. So according to the postmortem report, doesn't support this murder.
No.
Murder or homicide even.
Nothing. Homicide also is not there.
Already come to the postmortem.
Prosecution evidence is not there that this is a case of homicide.
Can't get to the postmortem examination report.
That my lord will find PM report issued for.
Exhibit 4.
My lord.
Mr. Kotukia, please help us when where that page, the paperbook page.
Paperbook is not there, my lord.
It is there. Open it. And the paperbook. That paperbook.
LCR.
That exhibits LCR. It is not.
The paperbook is not PCR. The exhibits are wrongly marked here. Here the difference is not the visceral report. The visceral report also not telling you not there. No, difference has marked it. Yes. It is wrongly. Exhibit. So that exhibit 4 is the PM report. Yes, what I age. Left hand problem. Sir, may the list of exhibits can go up. Sir, wrongly, completely standing wrong. Yeah. That was creating confusion.
Is 60?
60, just 60, 60 on the left hand side. Here it is written. Completely wrongly, it has been scanned. Cause of death is opinion reserved. Viscera preserved. Yes. After obtaining viscera also, it was not placed before the doctor for opinion. That is the categorical evidence. IO has not placed before the doctor to get the opinion.
It depends to produce the visceral reports.
Exhibit C or something like that.
All right.
Sir. Exhibit A, sir. Sir. Exhibit A. Insecticidal, alkaloidal, metallic poison could not be detected.
Okay. Everything is so wrong, absolutely wrong.
Just after the list of exhibits.
Okay. This is the result report.
Yes.
Okay. We now come to the evidence of harassment on demand of this dowry.
Yes, so far as evidence of PW 6-7 is the father and mother of the deceased, and let's say 8, 9, and 20. All are the relations of the deceased.
8, 9, and 20.
Yes, 6, 7, 8, 9, and 20. All 5 are relations of the deceased. They have said there was a demand over telephone. Deceased had informed them there was ill treatment with regard to dowry's concern. Over telephone. But the IO has not collected the CDR, nothing. But the evidence is that
the last occurrence of harassment, when it happened? Last occurrence of harassment.
So that is not there.
They did not specify.
No, that is not there. But on the other hand, independent witnesses that PW 1, 3, 4 and 15, 18, they have categorically stated that there is no dowry demand, no torture, no ill treatment. On the other hand, for all the family members of the deceased, that means in-laws, are treating as their daughter. Who are these witnesses? 3, 4, they have been The vital part involved, my lord, kindly see the page, para 22, page 61 of the judgment. Para 22, page 61, full and trial court, they have discussed the circumstances under which convicted under section 302 and 304B. Para 22.
Yes.
There is no direct evidence in this case that the accused person committed murder of the deceased. The entire case of the prosecution is based on the circumstantial evidence. The prosecution has already proved one of such circumstances that deceased was subjected to cruelty and dowry torture soon before her unnatural death in the in-law's house. The other circumstances according to the prosecution are the deceased was sleeping with her husband, accused Bimor, at the time of her death. Soon before her death, the accused Bimor supplied a glass of water to the deceased. This part of the evidence, this is the circumstances for which he has been convicted under section 302. Kindly see the 313 statement. This part of circumstance evidence has not been put to the accused. This part of evidence on the trial court has declared on the this evidence and on the basis of which he convicted under section 302, but this part of evidence has not been put to the accused. You will also kindly see the accused statement. The accused statement starts from the Bimor
79.
So yes, Malad. Bimor starts from 87, Malad. 87.
Yes.
Altogether 28 questions. That question has not been put to the accused. If that part of evidence will go, so there is no question of 302.
What about 498A?
And so far as 304B is concerned.
No, this part actually also doesn't relates to the 304B. Giving a glass of water and death is not unnatural.
So that on the basis that trial court has convicted 302.
Because the trial court at the time of reading the evidence, before preparing the questions for examination, thought this is not an incriminating There is no evidence?
There is no absolutely no evidence.
Harassment that these four witnesses, 6, 7, 8, 9, 20 said
Malad.
that you are demanding money.
Malad. So for that part of evidence, your lordship will be categorically if PW 6, 7, 8, 9.
He was convicted only under section 302.
302, 304B.
Both.
Both.
And also 498.
And also 498. It cannot be because Malad, very basic fundamental of criminal jurisprudence is there is no homicide. There is the question of 302. Number one. Number two, so far 304 is concerned, is the PW 5 and PW 9. Doctor, both doctors who said this is a natural death. Why the question of 304B?
No, they have not said natural death. Where have they said that it is a natural death? Opinion was reserved and no poison was found.
No, PW 5 and 9, they
will that the, you see the inquest report, the mother of the father, I don't know, it's really guilty. At the very first instance, he makes a complaint that बेटी की शादी के 2 रोज बाद से बराबर स्वामी विमल कुमार सोनसो उसे पैसों के लिए सोनसो
no, but another angle can you consider. They are very much present at about 3 p.m. 3 p.m. in their presence inquest was made, postmortem was made. Thereafter, at 11:30 number one. Number two, violence, the deceased over telephone information architecture. But after date of the deceased only, they will commit a case on the phone. Prior to that, they have no texture. Nobody has said. After date of the deceased, now they will commit a case. Deceased telephoning us. Deceased was saying that he was structured in the house. That is the entire case of the prosecution.
Whether any date, anything has been given. Date.
Malad.
When telephonic communicated, it is the out of the same transaction. Now, how the parents appeared in the place of occurrence? Who informed the parents?
Father-in-law.
All right. And what is the statement? Come to the father stating 6 and 7.
He did 6, Malad.
Gajanan Agarwal. 114.
Yes.
Page 114, Malad.
Yes.
Starts from 114. I am the informed and know the accused person that this is my daughter. I gave her marriage to accused woman on 9/5/2005. Before the marriage, the accused person demanded dowry of cash of rupees 2 lakhs, 1 full of gold, 2 half-set gold, 25 pairs of gold earring and other home appliances. We gave the cash as per the dowry demand before marriage and after demand are fulfilled at the time of marriage. 4 days after the marriage, well, this is more important. 4 days of the marriage, the deceased and her father-in-law demanded further dowry from me over telephone. This part of evidence was not in the FIR. At that time, they demand further dowry on diamond set, further 2 lakhs cash and 50 tola gold repeatedly. We are getting such phone calls. The deceased also complained before me for apprehension of torture upon her by her in-laws and husband on non-fulfillment of further dowry, demand of dowry, while she was visiting us at Pittigard. This part of evidence was not in the FIR. I consoled my daughter that time will help us everything, and I am trying my level best to fulfill their demand in due course. On 2/10/2005 at noon, I got further telephone from the house of neighbors of the house of the in-laws of deceased that deceased is dead.
Can you sit tomorrow? Pardon, but we will sit again on tomorrow at 4. We'll continue up to 4:30. Make a short, brief submission. You have got the outline of the case today. Your bullet point submissions you make in decision that I think you also decide that this is section 32 of the Evidence Act, where the evidence of the dowry is concerned. It is all coming after death of the person and not related to the death. Right? It can be a disconnect between these two. So you just, all of your grounds, you just put down your bullet point. All right, tomorrow we'll continue. It's a problem.
Tomorrow.
All right. You
Actually, we start with day after tomorrow because
okay. Day after tomorrow. Huh? Then it will go to 21st, I think, no? Oh, so you are going to change. So then on 8, can it be done?
The 22nd?
Can it be done on Monday, 18th? No.
No, I do lots of convenience.
Oh, no, this, then other day. You're coming back? This,
I'm coming back on 23rd morning, 21st, 22nd.
24th. 24th for the 4 p.m. Just 1 minute. The other matter is there. This other matter? All right, just a minute. Oh, these are two matters. You are Mr. Mahashar Manti.
No, I have been engaged, my lord. I initially has not been there.
Oh, Mr. BP Pradhan. You are legal aid counsel? No.
No.
Okay. BP Pradhan and counsel has made his submission in part. Then counsel with the appellant. Where the matter will be listed on 24th August at 4 p.m. along with CRLA 417 of 2008. Mr. S.P. Misro and his senior counsel, along with Mr. S.K. Jafarullah, was appeared for the informant, and Mr. J. Katugiel and additional government advocate is appeared for the state. So let us
24th, I have some percentage.
25th is all right. 25th again, Saturday. That will not happen. 25 is a Friday, no? 25 is a Friday.
Last Friday. It's last Friday.
No, Friday is there is a special bench is there.
Last Friday there is a chance. 25th. Last Friday there is a
on 23rd. On 23rd.
23rd.
And I think the proof relating to will be in the center stage of the entire submission, that whether it is a natural death or it is an unnatural death.
Correct.
This is number one. If it is not unnatural death, then both section 302 and 304 will be out of the consideration. Then the remaining part will be there is a 498A. So the London Council that way, the 1.5 page submission on bullet points, you prepare it.
Right.
All right.
May permit to mention manner. Restoration manner. My lord must have mentioned this bench My lord, Justice here, my lord, Justice here, that was one of member, my lord.
But we are not giving you any date, that will be according to our.
Yes, sir. The mention was there in the not in so.
Please, okay, take this. I told you, when there is a matter relating to a break bench, you go to this registered judiciary. We have instructed them, this bench has to be constituted. It's not a regular bench. In future, don't mention these matters before this kind of a break bench. Yes.
This is a application for restoration of the rate appeal, my lord. The appeal has been dismissed for default. I was not there, my lord. I had gone to my native place on that day. I pray, my lord, to restore the matter and maintain the
My lord, I am appearing for the open number 6, man.
7, 6, 7, 2 opposite parties, private parties. If it accepts notice for 6 and my lord.
We are in the judgment order.
Yes, my lord.
What page?
My lord, I have given the synopsis, my lord.
Talking about the copy of the order.
Copy of the order, my lord, is Annexure 1 at page 14.
Annexure 1?
No, Annexure. Appeal, my lord.
No, not the order by which this petitioner was dismissed.
No, well, that I have not annexed.
But the rule of the High Court, you have to annex the order.
I beg excuse, my lord, that I beg excuse for that, my lord. Only I have.
Why? It's you know.
Not annexed. Yes, my lord, I know, my lord.
Huh?
No, in the person petition, it's not annexed.
No.
Yes, my lord, that is the rule of the court, my lord.
No, this is not the way. You have to comply the rule.
Yes, my lord. Well, one appears for the appellant.
I find in this High Court, the judges are losing their 50% time to correct the technical matters.
I beg excuse. No.
Even registry is giving note, you are not even taking care of their notes also. We have to pass order, remove the defects.
So that is the defect, my lord. I have not annexed, my lord.
Any objection?
I beg excuse for that, my lord.
Adjournment, yes, my lord. Because he was absent, but yes.
Any objection?
No objection, my lord. Only there was a status quo order in that, and this is pertaining to a government land that has been illegally been encroached by the petitioner, my lord.
He is also
my lord.
Fixing a date on that day, if they do not, if they are not available, again we will dismiss the matter. We are restoring on condition that on that day the matter will be heard. We will take this.
I beg your pardon, my lord. Let him serve a copy of the record.
That's not the copy. What are you doing now? I will not pass it here.
This restoration petition we have. I have copy with it.
I have sought, my lord.
This I
have served all the papers to him.
Appeal I have solved. No, the restoration letter I have.
Mr. DK served.
He wants right to appeal.
Huh?
He wants a copy of the appeal.
Obviously,
I have given, but it was misplaced in their office. I want to dispose of the difficult to get.
He also supporting getting the copy.
Tomorrow.
A copy on the open number 6 also.
Yes.
Which copy?
Read up.
So let me consider for the applicant. Wait a minute. The number 506 of 2016, which was dismissed from the execution by the order dated 18/10/2023. As there was no representation for that event. So, which is Southern Council submitted there. Then you are not present. The matter was called out. Mr. Sahu from the council has submitted that on that day. He was not admitted to. There is no in his related to internet. For attending some class. Here's where we indicated that we have nobody mentioned the matter of the court. We brought a post notice for the website. Consequently, we did order first in present of the Mr. I. Wanted the additional study class. Mr. Trivedi.
Rakesh Tripathi.
Mr. Rakesh Tripathi from council. Appearing for the state opposite parties. Number 1 to 4.
1 to 5, my lord.
1 to 5.
My lord.
I'm for OP6, my lord.
Okay, yes. And Mr. You have already?
My lord.
No, in the appeal. In the appeal, all 6 and 7 have appeared. I think my lord,
that REIT appeal, the brief in the REIT appeal has been transferred, my lord.
Mr. R. Behra.
My lord.
When council is appealed from the opposite party was 6. Well, the council appealing to the opposite party and not oppose the same chair. Fair for restoration and limits. Recall the order dated such and such.
My lord, there might be a small technical difficulty. The petitioner who was in the REIT appeal has in the meanwhile passed away. So
I have substituted, given substitution petition, his widow.
Petitioner means is the respondent now.
The appellant. The appellant.
Who has filed this application?
The wife of 2 minor children. They have been substituted, appeal, my lord. So, yes, my lord.
Oh, okay. Substitute then is all right.
Yes, my lord.
There will be applicants, so I will just come in applicants. We do not find any impediment and we call the same order agent. Such and such. It is 18/10/2022. Will give you a number of purchases of 2016. And then result. The WNS purchases stands. It is true to its argument file. When the matter will be started on 14 September. 14 September 2023 at 4 p.m.
The assignments document.
14 September. It is very absolutely clear. When these orders are in the order passed in CFP execution, we will be restoring 14 September 2023. After 1 day, the matter will be taken up for disposal and no acknowledgement will be given. If there will be any, if there is no representation of the here, this will pass the order of non-execution.
Appeal copy should be given. Tomorrow I will give. Tomorrow I will give. Rajesh Tripathi. Yes. Yes, Rajesh Tripathi.
Rajesh. Okay. From Rajesh Khanna. This police